you very much, Senator Scott Monte. Any apologies for absence, Miss Secretary, Miss Rosa Marie Beckford?
Yes, well, Chairman, I don't have an apology for absence. Mr. Robinson is trying to join, but he is not near Wi-Fi, so I don't know if he'll get a chance to join.
Understand. Hello.
Senator Bunting will not be able to make it.
Sorry?
Senator Bunting will not be able to make it, Minister.
Who is that? You broke up a while ago.
Peter Bunting. Senator Bunting.
He will make
He will not be able to make it.
Okay, no problem. Fine. And I know Julian Robbins, he's in touch. He's abroad. I don't know if he will. I think he says he may try to join. Is that so?
Yes, Chairman, he's trying to join.
Okay. I know Miss Tova Hamilton is trying to join. Have you joined us yet, Tova? She said she didn't get the link, Miss Rosemary Beckford. Tamika, you're on. Davis is on. Tamika Davis, I was
calling you. Chairman, I just sent it to her.
Good. I know Miss Tova Hamilton is likely to join us very shortly. So basically, I just want to begin and just especially for the presenters to just note a number of matters in terms of the Zoom meeting. In particular, when we download, I'm just going to read what was sent to me by Ms. Beckford. Download the Zoom application to the device you wish to use for the virtual meetings. Ensure that the speaker and microphone on your device are working. Set up a visually suitable area for your backdrop. Well, dress appropriately, business attire. After clicking the link to join a meeting, type in your name and title, like, for example, Mr. John Brown or Dr. Jane Mitchell. All microphones and cameras will be muted upon you joining the meeting. To enable the camera, this meeting will not facilitate crosstalk or interruptions. Please allow the persons on the floor to finish speaking before you begin. To participate, and this is important to all the members who would like to participate or ask questions, raise your hand. I, as committee chairman, will determine when it is your turn to speak. Please unmute your microphone upon being invited to speak. Lower your hand, mute your microphone. Do not click leave unless you wish to leave the meeting. Okay, so when we begin, what basically we plan to do is to members, we are going to ask the presenters to make their presentation, highlighting the issues in their written contribution. We are going to be starting with the Financial Investigation Division, followed by JAM, the Jamaica Accountability Meet Portal, then Integrity Commission, Jamaica Lands, and then the Jamaicans for Justice. These are the persons who have indicated that they can speak, they can contribute or participate this morning. And then at the end of the meeting, we'll determine when we, 4 other persons who have made contribution, when we will invite them to participate, members. So basically, the format is fairly clear. So I don't know if any member have any concern before we ask the FID to begin. The minutes, Ms. Beckford, was it circulated? Even if it was circulated, I'm going to ask for it to be postponed until the next meeting. Is that okay, everyone?
Chairman, I was at the meeting, but in light of the fact that it was on housekeeping matters, I don't think it's something that we should delay. We could just go ahead and pass it.
I hope everyone can hear me clearly. Every now and then, Dr. Guy, you are breaking up. I don't know if it is your connection or mine.
No, I want to think it's yours,
everyone hear me clearly? But when you came on a while ago, Dr. Guy,
I'm hearing both clearly.
I think you need to do something about the one at the Ministry
I
of
don't know whose
Justice.
connection is bad. All right, no problem. So we're going to begin then, if it is okay. We're going to start with the Financial Investigation Division. Who is presenting for the FID?
Chairman.
Mr. Hay?
Chairman.
Yes, Dr. Guy, yes, please.
Yes,
go ahead.
I was saying that in light of the fact that the minutes of the last meeting were quite brief and that they only had to deal with housekeeping matters, I don't think it's something that we should detain us. We can go ahead and pass the minutes as confirmed and then move on instead of delaying it.
You're breaking up badly, I don't know why. Yes, Dr. Guy, you're breaking up badly. Sorry. Go ahead.
Chairman, if you can hear me, Dr. Guy saying though he
you,
was not present at the meeting, since the issues in respect of the minutes of meeting surround just housekeeping matters, he is proposing that we go ahead and adopt the minutes regardless.
Thank you.
All right. I suspect it is my internet here that is giving some trouble because, you know, I'm not getting the message across. So am I to understand then we can proceed now with the presentation? I didn't hear your comment, Dr. Guy. So,
I was saying, let us do the minutes. It is not long or exhaustive. It only deals with
so you would like to go ahead and do the minutes?
Yes, sir.
Okay, no problem. Can we then, are there any corrections to the minutes? If there are no correction to the minutes, can we have a confirmation, a motion to adopt the minutes?
So move, Minister.
Thank you very much. I seconded.
Seconded.
Okay. Any matters arising from the minutes that anyone would like to raise? What is happening to my thing? Check it out quickly for me, please. All right, if I must admit the connection is bad from where I am. You may be hearing me, but I'm not hearing anyone. Are there any matters arising from the minutes? If not, we can proceed.
I think you're hearing me, Minister, and I suggest we proceed. The meeting was merely procedural. No, you're not hearing me. Minister,
yes, Donna, I'm seeing you, but I'm not hearing you well. I don't know why.
You have to read my lips. I say that we should go proceed because the meeting was just to establish how we were going to meet.
That's my recollection.
Yes.
All right. So basically, thanks, Donna, and thanks, members of the committee. So the minutes are confirmed, and we are going to proceed now with to us. Mr. Hay, are you ready?
Yes, sir. Good morning, Chairman.
Right.
Good morning, other members of the Joint Select Committee, honorable members of the Houses of Parliament, distinguished ladies and gentlemen. I'm very pleased this morning to be here to present for you your consideration or comments on the proposed review of the Integrity Commission Act 2007. The Financial Investigation Division of the Ministry of Finance and the Public Service was grateful to have received an invitation to examine the Integrity Commission Act 2017 and to indicate whether there are any areas of concern or gaps or weaknesses identified, and to make recommendations for any changes that might be required to improve the legislation in December 2021. We were pleased to submit our comments for consideration in this regard on this act and reverted same to the Houses of Parliament by way of Committee Clerk, Mrs. Rosemary Douglas Eckford, on February 14, 2022. Specifically, comments were made on particular provisions of the Act where our agency anticipated points of departure with existing provisions. Amendments to the Act that were considered by the FID relate to the following 5 areas. 1, creation of a new section in the Act to not void the action of the Commission for want of form, consequent on repeal of Section 22 of the Contractor General Act 1983, with no equivalent section to protect the Commission. 2, streamlining ministerial approval for memoranda of understanding for information exchange per Section 7, subsection 12 and 13 of the Act. Deletion of any referral to gifts to parliamentarians, public officials per Section 40, subsection 4 of the Act. 4, creation of a new offense of misleading, obstructing, or non-compliance with regards to requests from Director of Investigation, contrary to Section 51 of the Act. And 5, restriction on disclosure per Section 53, subsection 3 of the Act. In going into further details, Chairman and members, point 1, the creation of a new section in the Act to not void the action of the Commission for want of form. Consequent on repeal of Section 22 of the Contractor General's Act 1983 by virtue of Section 58 and the 4th schedule of the Act, in light of the complexity and or then diversity of matters that the Commission and or a director may address, it is recommended that a new section be added to the Act that will provide that the proceedings of a Commission and or a director shall not be rendered void for want of form. Point 2, streamlining ministerial approval for memoranda of understanding for information exchange per Section 7, subsection 12 and 13 of the Act. Cooperation between domestic and international agencies in the fight against corruption remains a global challenge, and particularly where ministerial approval for cooperation between competent authorities and or foreign agencies with similar functions is required. This remains a potential stumbling block in the fight against corruption, and it also hampers or affects the independence of the Commission. Similar action from national cooperation and coordination are included under FATF recommendation 2 in fighting corruption, such that point 2.3 mechanism should be in place to enable policymakers, the financial intelligence unit, law enforcement authorities, supervisors, and other relevant competent authorities to cooperate and where appropriate, coordinate and exchange information domestically with each other concerning the development and implementation of anti-money laundering and countering of financing of terrorism policies and activities Such mechanisms should apply at both policy making and operational levels. Countries should have cooperation and coordination between relevant authorities to ensure the compatibility of AML/CFT requirements with data protection and privacy rules and other similar provisions. Example, data security or localization. The Act should be amended to facilitate same so that the Commission can exchange information with designated competent authorities and or foreign entities for legitimate investigations within an approved and standardized operational framework. Also, it is recommended that related information exchange policies, processes, and documentation be standardized and operationalized for the Commission, inclusive of database sharing protocol to mitigate the potential hindrance to investigation. These can be set out in a clear legal framework within the regulations that direct how to achieve such collaboration with approval authority residing in the Commission, with clear checks and balances to prevent abuse of power, abuse of process by the Commission. Or operational procedure is standardized and include the creation of a shared database or information platform with appropriate authorities, protection per agency. Thus, it is timely that the FID and the Commission recently concluded an MOU for the information sharing in December 2021. Similarly, as the Commission, the FID establishes domestic corporation and may, with the approval of the minister, enter into a contract, memorandum of understanding, or other agreement with a public body in Jamaica. These provisions are entrenching in both legislation. However, they provide operational difficulties, and as I said before, they hamper the independence of sharing of information and greatly affect the pace of the investigation. Point 3, deletion of any referral to gifts to parliamentarian public officials per section 44 of the Act. The third annual report of the Commission on page 22 recommended that section 40, subsection 4, which stipulates the deletion of personal gifts to parliamentarians and public officials from relatives on the basis that it is conceivable that a relative of a parliamentarian or a public official could potentially be a conduit for bribery, and thus the subsection can be seen as enabling corruption. The FID agrees with the deletion of this section, as gifts are included at the appropriate section of the statutory declaration per item 14 of the third schedule of the Act, and will help to mitigate the bribery and corruption mentioned. Point 4, creation of a new offense for misleading, obstructing, or non-compliance with the request from Director of Investigation, contrary to section 51. Similar to the offense, contrary to section 43, subsection 1B, relating to the work of the Director of Information and Complaints. Currently, the Director of Investigation is to be advised on government contracts and prescribe licenses inter alia. The award, variation, termination of government contracts, to have access to documents and to have access to premises where work on a government contract is to be carried out to be carried out. Thus, the inclusion of an offense contrary to section 51 was recommended, where the work of the director of investigation is obstructed or hindered, or where a person fails to comply with the director's lawful requirement, where a person willfully makes a false statement to mislead or misleads or attempts to mislead the director of investigation or any other person in the execution of his function under the act. The FID offers no objection to this recommendation if it will mitigate the provision of
Mr. Hay, just hold a second for me. Mrs. Holness, I'm going to ask you to take over the chairmanship for a while because my internet is very unstable. Is that okay? Dr. Guy, you wanted to comment at this time? But
no, I'll wait until Mr. Hay is finished.
Okay, Mrs. Holness, could you please take over the chair briefly for me? Because I am really not hearing Dr. Guy clearly. I'm going to try and go to another site because where I am, the internet is very unstable.
Please repeat the first part of your statement, Chair.
Yes, I'm asking you to take over the chair for me until I can get to a site where the internet is better. At the moment where I am, I'm just barely hearing Mr. Hay. So please take over the chairmanship for me until I can rejoin at a better site, okay?
Okay, Chair.
All right, unmute. So when Mr. Hay is finished, I think Dr. Guy would like to comment.
I continue.
Mr. Hay, continue.
Not hearing anything.
Are you through, Mr. Hay?
Yes, madam. May I continue?
Yes, Mr. Hay, continue.
Thank you very much. Well, I'm going to catch up. I'm going to repeat the point. Number 4, creation of a new offense for misleading, obstructing, or non-compliance with request from the Director of Investigation, contrary to section 51. Similar to the offense contrary to section 43, subsection 1B, relating to the work of the Director of Information and Complaint. Currently, the Director of Investigation is to be advised on government contracts and prescribed licenses, among other things. The award, variation, and termination of government contracts, to have access to documents and to have access to premises where work on a government contract has been, is being, or is to be carried out. Thus, the inclusion of an offense contrary to section 51 was recommended where the work of the Director of Investigation is obstructed or hindered, where a person fails to comply with the director's lawful requirement, and where a person willfully makes a false statement to mislead or misleads or attempts to mislead the Director of Investigation or any other person in the execution of his function under the Act. The FID offers no objection to this recommendation if it will mitigate the provision of deliberate misinformation and or obstruction of legitimate investigation. And point 5, restriction on the disclosure authority to comment on investigation. Section 53, subsection 3. Currently, the Commission is precluded from commenting on all matters under investigation. Thus, it is recommended that the Commission be authorized to comment on investigation. Subsection 53(3) of the Act addresses restriction on disclosure of certain matters and states, until until the tabling in Parliament of report under Section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no report of public statement shall be made by the Commission or any other person in relation to the initiation or conduct of an investigation under this Act. And I quoted from the Act. The section of the Act essentially restricts disclosure on investigation and prevents the Commission from making any announcement that it has commenced an investigation or from providing an update on an investigation until the tabling of a report. On January 25, 2022, Transparency International released its 2021 Corruption Perception Index, revealing that Jamaica had fallen one place from position 69 out of 180 countries, position 70 out of 180 countries. Jamaica's 2021 Corruption Prevention Index score of 44 out of 100, where 0 means highly corrupt and 100 very clean, remained unchanged for 2021 by Transparency International definition. A CPI score of below 50 signals that the serious corruption is pervasive in the country, characterized by prevalent bribery, lack of punishment for corruption, as well as public institutions that do not respond to citizens' needs. In commenting on the 2021 CPI ratings for Jamaica, the Commission reiterated in its repeated advocacy for revisions to the native Jamaica's anti-corruption legislative changes to this section in all 3 annual reports to Parliament tabled before the Integrity Commission Parliament Oversight Committee. The principle of disclosure is an accepted standard for anti-corruption agencies to promote the active participation of individuals in the fight against corruption by ensuring the public has effective access to information. Through disclosure, it is expected to engender greater public confidence in the independence, fairness, and effectiveness of anti-corruption agencies. Thus, this section seems to be contrary to this principle of transparency necessary to engender public confidence and cooperation. It is for these reasons and in support of the recommendation made for this section in the 3rd annual report that the Joint Select Committee consider this recommendation to make disclosure timely and relevant as these unfold, thus underscoring the transparency and public confidence that such provisions seek to engender. This, Madam Chair, ladies and gentlemen, concludes our submission to the Joint Select Committee on the review of the Act. Thank you very much.
Thank you, Mr. Hay. Recognizing Member Guy, whose hand is up. You may go ahead, Member Guy.
Thank you very much, Madam Chair. Mr. Hay, the remit of this committee is the review of the legislation that was enacted in, I think it's 2017. And the legislation calls for review after 5 years. Now, I listened to your presentation. Are you hearing me, by the way?
Yes, Dr. Guy, I'm hearing you clearly.
Thank you. I listened to your presentation on behalf of Financial Investigation Division. And I was just wondering if there was any other recommendations that the division made outside of those that came from the reports by the IC to the Parliament, because these are not the only things that we are looking at. Those are what the IC Integrity Commission made as their recommendation to the committee. I'm gathering from your presentation that all of the FID has done is to either support, for reasons that you have outlined, the recommendations coming from the Integrity Commission. What I want to know is whether you have any de novo recommendations from your committee, your division as well, outside of what came from the Integrity Commission in their report. And secondly, you mentioned that in the Transparency International definition, and I'll read here as you did, by the TI definition, a CPI score of below 50 signals that serious corruption is pervasive in the country, characterized by prevalent bribery, lack of punishment for corruption, as well as public institutions that do not respond to citizens' need. Now, you know, we always try to broad brush a country by quoting such. I would like to know if there's any interrogation of what percentage of that corruption in the below 50, right, is attributable to prevalent bribery, attributable to lack of punishment for corruption, attributable to public institutions that do not respond to citizens' need. I ask this against the background that it could very well be that in some of those countries, and I don't want you to misunderstand my position, because I am against the whole aspect of corruption, but I want to know that we are on the same page when we say that corruption is endemic or corruption is prevalent in a particular country, and what are the bases for those elements of corruption as defined by TI. So it is easy to accept that TI says that anything below 50, any country below 50 is attributable to these three areas. But have we gone any further to say what element of those three are responsible for the greatest level of corruption to give us an index of below 50?
Thank you very much for that, Dr. Guy. In using the extract from the corruption from Transparency International, what I was aiming to do was to show the correlation of this perception. Because remember now, ladies and gentlemen, every year when we get this CPI score or indication, it's really a perception. And so what I was using that was to say, when we have an important entity like our Integrity Commission not being able to speak to the country or to articulate some of the work that they're doing, then we run the risk of cementing, for want of a better word, that perception that nothing is happening, that our entities are hampered or restricted from doing their work and things like that. Those are important.
May I just jump in here? ACP, sorry. Hey.
Yes,
through you, Madam Chair. I've been listening keenly. Just let me ask, were we supplied a copy of your presentation? I was looking through the
It was supplied, Madam.
It was sent? All right, I haven't seen, I've seen the others, but I didn't see yours, but I listened attentively. Don't you mean to overtake your issues?
Sorry, Madam, the presentation was not sent, but what I did was to extract from the documentation with a more substantive submission. So I just picked out some salient points from it, but it was a more comprehensive document that was sent to the committee.
All right. Go ahead. I'll wait until you're finished responding to Member Guy.
Right. So what I'm saying to Dr. Guy in response was that the use of that extract was to cement the point that we run the risk of concretizing these perceptions if transparency is not addressed. And as I said before, this is a very important anti-corruption commission or agency for the country. And so that's why we want to look at it from those perspectives. The other aspect of your question regarding whether or not the FID had any other concern from its perspective. So I mentioned the fact that we signed up an MOU with the Integrity Commission in December. And I was using that to highlight the fact that the restriction that prevailed in both entities, two very important entities, in treating with the problems that we're faced with, in sharing information and working together, it would make life a lot easier for everybody, and the results would be more fast-paced and I dare say even more comprehensive if we are able to freely share the information and interact with each other. As I outlined in the presentation, there are provisions that could be put in the regulation, and there are mechanisms that can be used to ensure that the sharing of information is handled in a very responsible and secure manner.
So you're, Madam Chair, if I may follow up, you're saying basically then, Director, that the syncing of your comments with those of the IC was as a consequence of the MOU?
No. What we're saying is that in getting that MOU, we saw where these restrictions would have contributed to some of the difficulty in sharing the information and working in a more seamless manner. That's the point I was trying to make.
Okay. All right, thank you.
Member Malahuford.
Already.
Thank you, Chair. Sorry. I just.
Mr. Solis, I think I seem to be getting a bit connection, so we can join the chair.
No, thank you, Chair. No, thank you.
Or if I need your help again, I return to you. Thanks.
Thank you.
Minister Ford, you would like to intervene?
Yes, Chairman. I'm really trying to get as thorough an understanding of the concern that the restriction on speaking about matters under investigation until the tabling in the Parliament of a report under Section 36, how it is timing the work of the IC as reiterated by DCP Hay. I really want to know whether, and let me, so the category of public officials who are obligated to report go beyond members of the political directorate, but let me use the political directorate as an example. Whether the work is being stymied or interfered with by anyone from the political directorate. Because the more I hear reports in the media, especially over the past many weeks, the more concerned I have grown about how comments may serve to undermine processes and also undermine confidence in institutions. And I'm just trying to understand, because the provision says that it is until the tabling of the report how the investigation is to be dealt with by the Integrity Commission. I really want to know what my own difficulty in articulating the concern is perhaps reflective of the difficulty I'm experiencing in properly understanding the concern, because I am personally speaking for myself, unapologetic in my stance against corruption and in favor of integrity. And I know sometimes the impression is given that everyone in the political directorate is either a crook or a criminal or is incompetent. And a constitutional question which is arising and which we will have to put out there is the extent to which the unelected for the proper functioning of the democracy, the interplay between the elected and the unelected on matters of accountability. It's a question that is not only arising in the Jamaican context, but broader afield. And I really am struggling to understand.
Ford, if I could assist you, and maybe Mr. Hay could also respond along the same lines, because most of the other presenters are themselves, commenting on sections 36 and 53. What my understanding, when I was a party to this legislation and I promoted it, and I will still defend section 53 until I can be shown otherwise, that what we are saying, Mr. Hay, the investigation, once an investigation begins formally, then report it to Parliament. That would mean that the Speaker of the House would expect a report, and that investigation may prove to be benign. So at least Parliament would know that an investigation has started, and eventually a report will come, and the result of that investigation would be known to the Parliament and to the country.
So, Chairman, if I may just interrupt you, I think part of the concern is probably how reports are dealt with by the Parliament routinely. Matters are not debated. And I appreciate the concerns, I appreciate some of the concerns, but there are many things that I find mind-boggling. And the more I hear comments being made in the public from important office holders, and you assess how they are impacting confidence in offices, in the democracy, important offices of state and government, is the more I wonder about how do we properly provide for what we say we have committed to do. Because I am not necessarily persuaded that everything needs to be commented on in the public sphere at a particular stage, while I fully appreciate the importance of indicating publicly what is being done. I think the fight against corruption is much more than announcements that are to be made. I think we need to go to the culture of how things are done in Jamaica. And I believe a program, whether within government, in the wider society, of public education is within the remit of the IC. But like everything else, those matters take time. When we're talking about a cultural adaptive challenge, it's going to take time to yield the results. And we want instant gratification in just about everything that we seem to do.
Minister Ford, let me just say this. I'm sure that all the other participants, because glancing through, they're going to be coming back to this very point. But if we could just get from the contribution from FID, Mr. Hay, what why would you object to having a presentation in Parliament to say an investigation has begun, as against a press release from the Integrity Commission, which, as far as I'm concerned, is maybe at most a wait of a week before it is the release, the so-called release, is presented to Parliament to say that there will be an investigation of a contract between this any ministry and a particular contractor. Why does it have to be by a press release? Why can't it just be a statement to Parliament, and Parliament can release it to the media? That is a concern I'm having.
Chairman,
I just want your comment on that,
thing.
Mr. E, because I'm sure other people will also comment on it.
May I, Chairman?
Yes.
I don't recall making the point that there should be a press release. What I was really, well, maybe I was misunderstood, or maybe I wasn't as clear as I ought to have been, because I'm really not sitting here requiring that or suggesting that there should be whimsical release of information about an investigation. As someone who has worn hats in different areas of anti-corruption and otherwise, I am very in tune with the fact that an investigation, an investigation that surrounds sensitive matters and confidential matters have to be handled very responsibly. And so I am not here thinking that there should be this whimsical release of information to the public. What I was supporting is that whether or not a request is made to the commission by a responsible entity to say whether or not an investigation is being done, whether or not the commission can say to that entity or to the public, yes, an investigation has commenced, and we therefore will be able to discuss this further whenever the investigation is completed and we have reported to Parliament. I'm just saying there are mechanisms that can be used to responsibly release and update, rather than thinking of this whimsical release of information that can tarnish persons.
Well, Mr. Hill, and that is the concern. You would support then, because in your paper, by the way, Minister Ford, there is a paper submitted to Parliament, because your concern with the Section 53 is that it prohibits disclosure.
Right.
And our position is that Section 53, at least my position, is that it does not prevent disclosure. All you're saying is that disclose it in Parliament. Say to the Parliament, you have started an investigation. That's all you're saying.
But what they're saying is that they distrust parliamentarians to handle matters. At least that is a subliminal message. No, don't. DCP here, don't take this personally. I'm not personalizing the matter. And I understand where you're coming from. So just hear the point. I think at the heart of it, certainly from my perspective, is distrust, outright distrust. Because I am still struggling to understand how the restriction until the tabling impedes the work of the commission. I honestly am struggling to understand it.
No, Madam, the report that I have just outlined, or the concerns that I raised, were twofold. One was the difficulty in sharing information among designated authorities. For example, government of entities that work together on matters of corruption or money laundering. That is one issue. The issue around the non-commenting on the investigation really speaks to the issue of disclosure and transparency. That is the reason why we are raising it. Not as I keep repeating that there should be this whimsical approach to how we handle confidential information. And I think there is a way, and the chairman has been saying that Parliament is the body that, or is the avenue.
All right, through you, Chair. So what does the provision say? It says until the tabling of the report tabling in Parliament of a report under Section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential. And no report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of an investigation under the Act. All right. Am I to understand, DCP, that it is the interpretation of the FID that this wording prevents even a sharing of matters where investigation is being done jointly or there is reliance on one agency? That cannot be done because the keeping confidential is so interpreted, and the reporting or public statement impacts that?
No, madam, there are two separate issues. The issue,
asking again for clarity because I'm really seeking to understand. Yes.
You're right, ma'am. So there are two separate issues. One issue is in point, I think it was point 3, that we mentioned that the need to get the permission to share or to enter in an MOU, that hampers the pace and
whose permission is required, because there is a provision in the law, I don't now recall whether it requires permission, which authorizes empower the entering into agreements. That provision requires an authorization.
Yes, ma'am.
Let me look back on it.
What section specifically, if you recall, Mr. Hay, that prohibits it?
Section 77, subsection 12 and 13. 7, subsection 12 and 13.
So you'd want that particular section to allow the sharing of information.
Yes, Chairman. And it's a reality for us that it also includes provisions in our the financial investigation division, which has caused some international fallout from time to time, because it looks at independence and such. Not just independence, might add, but as I keep saying, the hurdles that it places in getting the information in a timely manner to ensure that the investigations can progress smoothly and sometimes more comprehensively. So it is a reality that we're faced with.
Sorry, section 72, you said?
7 subsection 12 and 13.
Oh.
7.
There's no 72.
No, it's 7.
All right, so let's look at let's look at it and see what the concern is. So 712. Okay, 7 itself says that the Commission may, in the performance of its function, work in cooperation with any person or body as it may deem appropriate. And then at 12, you say, subject to the provisions of this Act, the Commission may, with the approval of the Minister, enter into a memorandum of understanding with other agreement with a competent authority or a foreign agency whose functions are similar to the functions of the Commission under this Act regarding the sharing or exchange of information with the Commission relating to the prevention, detection, and investigation of an act of corruption. And you're saying that the requirement for the approval of the minister is what is posing a challenge. Has any request for approval been made which has been denied? I know it's a delicate question.
No, it has not been denied, but the time that it takes to get the approval sometimes really hampers the pace.
And in the past, when the request has been made, what kind of time frame that was involved in securing the approval, which resulted in a hampering of the work?
Actually, you know, Minister Ford, with the new, to the best of my knowledge, it being a commission of parliament, I don't think we should have any difficulty, you know, when we examine this to say that that phrase, you know, could be reconsidered with the permission.
Minister Chuck, there are two limbs. One is also with a foreign agency. Yes. The matter is not as simple as that.
Oh, I see. With the foreign agency,
policies are involved in terms of cooperation with foreign agencies. The matter is not as simple as it appears on the surface.
Okay.
But what you do not want is any delay in approval or the approval process creating any roadblock, as it were. But there are proper matters that would need to be assessed at a policy level, and that when ministerial approval is provided for, it's really speaking to matters which require policy.
Right, okay.
Right. However, Madam, the operational aspect of what we do, sometimes the policy decision impacts the operational reality. And that is where we're saying that if there could be that demarcation, then I think it would solve the problem.
So DCP, you know that policy is not determined in a vacuum, and it is also formulated in collaboration with persons. The distinction is between operational matters and policy matters, but ultimately matters of policy are dealt with at the cabinet level.
I am aware.
Right. So for me, is what is the process that is involved and who has the authority to do what? Sometimes authority is exclusive in one domain, sometimes it is shared. But at the end of the day, my concern is to ensure that the provisions are not creating problems that then result in achieving the goals, problems that, you know, prevent the achievement of the goals. But we shouldn't look at certain provisions and react to them on the surface to say it is causing, whether it's a reaction within the political directorate or a reaction outside of the political directorate, is to understand to whom are the functions given and by whom should they be exercised.
Right. Madam, I am trying to outline the reality that we face. For example, the FID through the FIU is empowered by law to share information and to gather information from foreign FIUs, specifically FIUs that are countries that are members of Egmont, of which Jamaica is a member. And that very provision is causing a lot of headache. I don't know if you recall in your previous office that there's an issue that we're dealing with currently that is threatening to derail Jamaica's membership. So I'm saying if there can be a way to deal with the issue that satisfies both the policy requirements and the operational independence, then I think it's something that is worthwhile for us to look at.
I understand.
All right. We have gone a long time with you, Mr. Hay. Are there any other points members would like to raise, or are there any conclusion point you'd like to make, Mr. Hay? All I would like to say, we'll give consideration to the points that you have raised. Okay.
Thank you very much, Chairman, and thank you very much.
And Minister Ford, there is a document that was presented by Mr. Hay. All right.
Right.
So I want to thank you very much, and members, please, we will note the points as we will indicate to you, Mr. Hay. A matrix will be prepared that identify your main points and the sections that you're asking for adjustment, that the committee will consider the matrix when we have heard all the submissions. Okay, so thanks very much for your presentation.
Thank you, sir. You're welcome. Thank you very much.
Then as the Jamaica Accountability Meter Portal, who is presented on behalf of Jamaica Meter.
Mr. Chairman, if I could just intervene, just to let you know that I'm now participating. I know I had asked my colleague to apologize.
You were having some difficulty, but once you're on and you want to participate, you could just raise your hand if you have any questions. Or...
Oh, I think I had been expected to be absent, but instead I'm just late.
Well, we will, please raise your hand as soon as you get the chance so we'll know you're here. All right.
Yeah.
If you have a question or comments, all right? Thanks for joining us though, Member Bunting. All right, JAMP, Jamp, are you on? Is anyone from Jamaica Accountability Meter Portal? If not, we are going to go to the next presenter. Miss Beckford, did you get any confirmation from Jamaica Accountability Meter Portal?
Yes, Chairman, up to yesterday, they confirmed that they would be presenting this morning. I'm not sure what has happened since.
Have you seen anywhere that they're on?
No, I don't see Miss Calder. She's not on right now. I'll find out what's happening.
While we have waited, maybe you can touch base with her. I think if the Integrity Commission doesn't mind, we could take a shot. I think Miss Jamaica Lands is not a long presentation to the best of my understanding. So could we take them first? Are you on Lands? Mr. Smith?
We are on, but we'd be comfortable having Integrity Commission go before us.
Okay. All right. So, Mr. Christie, are you there?
Good morning, Chair. How are you?
Very well, thanks. And we see you're well, so you can proceed.
Yes, Chair. A pleasant good morning to you and the members of your honorable committee. We're privileged to appear before your committee today, Chair. First, I just want to convey greetings from our chairman, Mr. Justice Panton, and our commissioners, and also to introduce my fellow colleagues who have started responsibilities on the Integrity Commission Act. I have with me this morning Mr. Craig Beresford, who is our Director of Information and Complaints. Also, Mr. Kevin Stevenson, Director of Investigation. Mrs. Keisha Prince Kamiko, Director of Corruption Prosecution. Mr. Ryan Evans, Director of Corruption Prevention, Stakeholder Engagement and Anti-Corruption Strategy. Mr. Maurice Barrett, or Manager of Anti-Corruption Policy and Strategic Engagement. And finally, our legal counsel, Mrs. Evian Ortiz. Chair and honorable members of this Joint Select Committee, we're here pursuant to the provisions of Section 60, subsection 1 of the Integrity Commission Act, which requires a special Joint Select Committee of Parliament to be established to review the Integrity Commission Act from time to time. And the first review is required to be undertaken within 5 years of the appointed day. And the appointed day in this case was February 22, 2018. So it's quite appropriate that the commission is here. I, however, also want to allude to Section 6, 1, H, I, and L of the Integrity Commission Act, which is, I think, germane to our presence here, Mr. Chairman. Section 6.1 of the Integrity Commission Act outlines the functions of the commission, and there are roughly 16 functions. And the three that I've highlighted, one of them is to monitor current legislative and administrative practices in the fight against corruption. The other one is to advise the minister on the adoption of international best practices related to the prevention of corruption. And the third is to advise the minister on such legislative reform as the commission considers necessary to reduce the likelihood of the occurrence of acts of corruption. It is these provisions, Honorable Chairman, which have instigated or considered recommendations to this committee. And what we have done, Chair, is that we have provided 3 submissions to your committee, and your clerk, the clerk of the committee will attest to this. The first one was submitted on February 10, 2022. It had 18 recommendations. Yes, the first 11 deal with recommendations which impact provisions in the Integrity Commission Act.
When the second one is when?
No, the first one was February 10, 2022.
Yes, I have that one. I just trying to check. And
right.
The second was?
Okay. Before I go, Chair, there are 18 recommendations in that, and the first 11 are the ones that we're concerned with this morning. The remaining 7 speak to other pieces of legislation, which are germane to our work, but it's not recommendations which are addressing revisions to the Integrity Commission Act. The second submission we made, Chair, was on July 4, 2022, which was Monday of this week. And essentially what that was, Chair, is something that you're familiar with. It was a position paper which we tabled before the Oversight Committee last year, which elaborates on our position with respect to Section 53.3.
And this you said was sent this week?
Yes, on Monday.
Regrettably, I don't have that, you know.
Okay.
I have read those. I have read those.
But I think, Chair, you probably are familiar with it.
I understand, yeah.
It was tabled before the Oversight Committee. But it elaborates on item 7 in the February 10, 2022 submission. So we just thought that for your ease of reference, we would, avail you with a copy of it.
No problem.
Chair, have other members had sight of that Monday submission? Because I haven't.
No, neither have I. I mean, but
irrespective of whether it was
with the February 10th submission. But you also said
it came in on the mail that had the Zoom link. There were attachments to that mail.
Oh.
Yes, three attachments.
Oh,
cover letter.
There's a third copy. There's a third submission.
There's a third submission, Chair and honorable members, which was also submitted to the clerk of the committee on July 4. Yes, and that is it's entitled Statement on Section 53.3 and the Bloomberg case.
Okay.
And it's a statement that the commission thought it was necessary to make with respect to that particular matter.
No problem.
Okay, Chair. So we were told this morning that we're invited just to overview those submissions and to speak for 15 minutes. So what we will do, Chair, with your permission, is just to quickly overview the first 11 of the 18 recommendations, which are contained in the February 10, 2022 submission to your committee. Okay?
Okay.
If you have that document in front of you, Chair, there are 4 columns in the document. The first column numbers the items. The second column outlines the recommendation and the supporting narratives. The third column gives a publication period. And I should just state that the Integrity Commission is currently in its 4th year, and it has filed 4 annual reports to Parliament. What we have done is that we have extracted from those 4 annual reports all recommendations. So for amendment to the Integrity Commission Act. So what you will see in the 3rd paragraph is a reference to the annual report where the recommendation was made and the page, right? Just for ease of reference. And of course, the 4th paragraph speaks to status And we thought that that was important because the Inter-Commission Parliament Oversight Committee on the chairmanship of Honorable Edmund Bartlett has already started the process of looking at some of these recommendations. And you'll be aware of that.
I'm aware of it.
Right. So what we have indicated in that fourth column are any instances where the particular recommendation has already been subject to examination by the Oversight Committee. Okay?
No, fine.
Okay, so if I could then, Chair, I'll just quickly run through, and I'm going to be calling upon my colleagues, recognizing that only the statute, they have specific statutory authority and responsibility on some of these issues. So I believe that it's only appropriate that the committee hears directly from them with respect to any of these matters which fall within their legislative purview and responsibility. The first one, Chair, is staggered and transitional arrangements of board membership. And this is coming from the very, very first annual report, at which time the commission was under the stewardship, the chairmanship of Justice Carl Harris, who has since resigned. And what this is alluding to is that Section 10 of the Integrity Commission Act states that a commissioner, an appointed commissioner, should serve for 7 years. And the concern that I'm assuming that they had then, this is going back 4 years, is that if all the commissioners were not to be reappointed after their initial 7-year term came to an end, then you have a new slate of commissioners, except for the office holder of the Office of the Attorney General, which is a standing appointment.
So you simply want an adjustment, a staggering of these.
Right.
Okay.
So,
No, okay.
But you know,
So
Chair,
want
it has sort of self-corrected itself so far, not in its entirety, but as you know, we had 2 resignations. Justice Carl Harrison resigned as chairman, and he was succeeded by the second judge that we had on the commission, who is Justice Seymour Panton. And Justice Seymour Panton's position was replaced by Justice Lloyd Hibbert. And Derek McCoy, Commissioner Derek McCoy, resigned in December 2019. He's our Attorney General, and he was replaced by Wayne Powell. So Wayne Powell and Lloyd Hibbert, their tenure would have been staggered.
Okay.
But that doesn't necessarily resolve the issue. But I think you see what point.
You just want an adjustment in the legislation that there's a staggering. So ensure there's a staggering.
One example, Chair. I had worked in Trinidad on the Office of the Procurement Regulator legislation, which is akin to the Office of the Contractor General legislation. And they have a board, I think, which has about 12 members. And what they did was to stagger the tenure of the members of the board, 4 years, 3 years, 2 years. So you'd always have, you'd never have a cold board.
No, that makes good sense.
Okay.
Yes.
Just to say, Chairman, we do have that model in the jurisdiction currently.
We do.
Yes.
Okay. Thanks, Chair, and thanks, Madam Malabu Fort. I can go to the second one, termination of the appointment of a commissioner, and I'm going to ask Maurice Barrett to just quickly address this one for me. Maurice.
Thank you, Mr. Christie. Good morning, members. Good morning, Chair. On the second recommendation, which is listed in our formal submission, it does speak to making an amendment to Section 15 of the current legislation to remove reference to the Governor General for the termination of the appointment of a commissioner, specifically to Section 15.1. In so doing, we are of the opinion that the reasons for termination remain valid, but just that the procedural requirements which are outlined in subsections 2, 3, 4, and 5 of the said provision be relied upon in all instances, rather than this delineation between Section 15.1, which authorizes the Governor General to do so without an investigation, versus the others which rely upon the formal constitution of a tribunal to consider the removal of an appointed commissioner. Thank you.
Thank you, Maurice. The next three items are, Chair.
Sorry. Chairman,
Go ahead.
can we just spend a little time looking back at that recommendation?
You want some more time, Minister Port, or?
You may proceed. We can come back to it after.
All right, go ahead then.
Yes, Chair. Thank you. The next three matters, they're entitled Examination and Completeness of Statutory Declarations. That's recommendation number 3. Disclosure of registrable interests. That's recommendation number 4. And gifts to parliamentarians, public officials from relatives. That's recommendation number 5. I'm going to ask my colleague, Mr. Craig Beresford, who is the Director of Information and Complaints, to speak to overview these three matters. And as you recall, Chair, the whole issue of proposed revisions to the statutory declaration regime had occupied a great amount of time before the Oversight Committee in its meetings of last year, October and November. Craig?
Is he on?
Thank you, Edie. Chair, honorable members, trying to get the video on. Okay, great. All right. Thank you very much, Chair. I'm going to first treat with the issue of examination and completeness of statutory declaration. Now, the functions of the Director of Information and Complaints are set out in section 32 of the legislation. And I'm just going to zoom in on the first provision, which states that the Director shall receive, keep on record, and examine all statutory declarations filed with the Commission. Chair, honorable members, we are of the view that we need to clarify some language, in particular in section 42, further around under the section that treats with our functions. We would like the honorable members, Chair, to consider clarifying certain words, the words examine, duly completed, and compliant. And this is because we have to review up to, well, at the time we made recommendation, it was 31,000 declarations that we were to receive from public officials, including parliamentarians. That number is now at about 40,000. We're not sure where it will go when there are other changes that are on the horizon. So what we would respectfully ask is for those words to be clarified so we can get a better appreciation of the effort that is going to be required for us to be able to examine all these declarations to ensure that they're duly completed. So
what's the challenge you're experiencing in the interpretation of the word examine, duly completed?
Well,
what is the practical difficulty?
Well, there is no practical difficulty as it stands. We just want to ensure that each person have a clear appreciation of what examine is, both ourselves and our stakeholder. Examination, we would have utilized the same methodology and approaches over the years. And of course, we would have improved it based on changes in the environment. So we just want to ensure that those words are clarified so that in the event that there's any ambiguity. Yes, sorry.
So has there any, have you indicated what you do from your end on the inside in discharging the function of examining a report? Because
yes.
I don't know if the public can perceive examination to mean one thing. What I'm sensing is that you're saying what we do is something very different from what the public those who are impacted may believe an examination involves, but isn't it a close inspection of whatever it is? So perhaps if you indicate what it is that you do in discharging the function of examining the submission, the declarations, then we could get a better understanding of what the challenge is. But I think to say it without more does not certainly explain to me what the challenge is.
Yes.
and appreciate your comments, member. But as it stands, we just want to ensure that there is one standard definition so that all stakeholders are aware. But if you are...
What does the IC do for examination? What does examination of a statutory declaration entail?
How do we know when it is complete?
Correct. So, all right, as it stands, examination will entail ensuring that all the required documents are affixed that are required to be submitted on the one hand. Also to ensure that all fields are complete. And then we have to also ensure that the information is correct. So that will constitute examination.
Because PBCJ, they want to see. Sorry, go ahead.
Yeah, I would have just set out that we examine the statutory declarations to ensure that it's completed, i.e. all fields are properly completed and all supporting documents are fixed, and also to verify that the information is accurate. So those are the 3 steps that constitute examination.
So that section 42.1 says that the Director of Information and Complaint shall examine or cause to be examined every statutory declaration that is submitted in order to ensure that it complies with the requirements of the Act. And one of the requirements of the Act is that the information provided must be accurate, true and complete.
Correct.
So I'm again now at a loss in understanding wherein lies the challenge of construing what examination means. Because if you believe that the public would not understand that part of examination means verifying the accuracy, then I think that issue would be addressed when you look at what is the purpose of the examination is to ensure compliance with the requirements of the Act.
Indeed. I think as it stands now, we have no objection to crafting the language that we could include in this section, definition section, as to what each word means. I think
we don't define words that have ordinary meaning, Mr. Beresford. There is no technical meaning to examination in this sense. Right?
Well,
but if you ever have a challenge with interpreting provision, the Attorney General's chambers can always advise can always assist in that way, or you can get advice legally. But when words are not defined, they are taken in their ordinary grammatical meaning in context.
Indeed, and I take your point, honorable member. However, as I said, it's not a case of trying to add a new meaning, but just to clarify to persons, to stakeholders, what examination means, because
maybe that's a function of it. Maybe that it should be done by way of public education then, and not a legislative it's not a legislative solution that is required to address any problem that arises on that front. But the problem can be addressed by your discharging the other functions of public education.
Indeed. Point taken, honorable member. I will just move to the next, as it concerns the issue of Part B of the statutory declarations, where the chairman of the commission is required to certify that a full declaration has been made. We are recommending that the language change to state that a declaration has been made, because the chairman who is signing off on the document is not the person who has undertaken the body of work that is required for him to attest that it's full. So we hope that we'll find favor with the members.
Chairman.
Yes, Dr. Guy.
I don't understand the last part that Mr. Beresford, the point he made, irrespective of the fact that the chairman was not the one who did the legwork, and chairman is acting on behalf of the official.
Good point. Before Mr. Bunting would like to also ask a question. Member Bunting, you'd like to ask a question too?
Yes, thank you, Mr. Chairman. it just seems to me that in that particular section, the Prime Minister and the Leader of the Opposition, it's referring to the publication of the summary of their statutory declarations. But the full declaration, as I understand it, is referring to that they have made a full declaration going beyond what is just in the statutory, in the summary declaration. So I'm understanding what the chairman would be certifying is that the summary of the statutory declarations of the Prime Minister and the Leader of the Opposition is published, but that a full declaration of the Prime Minister and the Leader of the Opposition has been made.
That's my understanding too. That one full means that the form is submitted, not just a summary that would be published, but that you have completed the declaration.
Chair, can I make a
before
comment
Mr.
here?
Christie comes in, there are two elements to that particular part B. One that deals with the declaration by members, and then it goes on to say, additionally, in relation to the publication of the summary of statutory declaration. Now, so there are two matters that have to be clarified here, right? Member Bunting spoke to the latter, but I still want to speak to the former. Because my point that the chairman has to certify, if he's the officer or the entity, the agent who certifies on behalf of the commission, then certainly he has to act on behalf of those who work for the commission. So there are two separate points that are being discussed here, and I think we should take them in order, although they might be related towards the latter part of it.
Let's see, Mr. Christie. You can help us, Mr. Christie.
Just a viewpoint, Chair, which hopefully will clarify the discussion. I think the question here has to do with the capacity of anyone, whether it's the chairman or the Director of Information and Complaints, to certify that a full declaration has been made. I don't think anybody in the commission can look on any declaration and say it has been a full declaration, because you really don't know. And I know that that's part of the discomfort that our chairman has with it. You know, let's say, for example, someone declares that, you know, these are my assets, 1 through 10. We don't know if he has 11 through 20. So you can't say a full declaration has been made. You really don't know. You may have to further interrogate.
No, Mr. Christie, with respect, I think what you're saying there is whether it is an accurate declaration. But I think the full declaration versus the summary declaration is something completely different. You, the chairman, or no one in the Integrity Commission could, could state that any third party, any parliamentarian, any public officer's declaration is accurate. But to say that they've done a full declaration, I think is a full versus summary, or that they have completed the declaration form in full. The accuracy is another matter, which I completely agree with you.
Member Bunting, I guess it comes down to your definition and my definition of the word full. You know, we could discuss here what we mean by full, but I'm sharing with you the concern that the commission has, that the word full, I mean, we could say it's ambiguous, we could say it's equivocal in meaning. And the concern is that no one is in a position, and I take your point, full could also connote accuracy, and that's exactly the point. No one is in a position to say that this declaration is fully accurate or it's a full or a complete declaration. So it's just the challenge is just to find the appropriate language for whoever is certifying to say, okay, we're certifying this, but you know, so and so. And that's all there is to it.
It seems to me that a problem is created internally, because if the understanding in that particular context is a complete declaration, a declaration as opposed to a summary of your assets and liability, then it does appear that, I mean, the question on the inside is what it is. But I suppose if there is need for clarification, is that a declaration form that is complete, has been submitted in addition to the summary, is really what it is getting at.
Member, if I could just read from the verbatim statement in the recommendation, because again, I should make the point that the recommendations that are here are the considered recommendations of the commission. This is what they have signed off on. So I'll read exactly what is stated here. The terminology full would connote that the chairman is confident that all assets, liabilities, and income have been declared by the respective parties. All elements of the statutory declarations have been thoroughly interrogated, and that no matter requiring investigation or further action on the part of the commission will arise. That's the comment that's there. That's the narrative that is there to support the point that is being made. And I can't go behind that.
It
that
does,
is what has been signed off.
one of the ordinary meanings of full is complete in details. So it does appear as if there is questioning around whether the fact that question may arise as to whether a declaration submitted by a declarant complies with the provisions of the law is something different from whether a declarant has fully completed a form and submitted it, as opposed to sending in statute a summary of their assets and liability.
And Madam Member, that's precisely the point. The word full is equivocal in meaning. You could allocate one interpretation to it and the other person could allocate
May
another.
I just ask, so far, how does the commission interpret the word so far in receiving those categories of declaration, that the two that require a summary to be provided and the full declaration? How is it interpreted?
As far as I'm aware, Director Craig can correct me. I think our chairman has opted not to use that term.
Has any, for those matters, have they been signed off on or they remain pending?
Director Craig?
As it stands now, we have advanced those matters without saying full.
So what language, what have you said in advancing those matters? I mean,
that the declaration has been made. And it's as the ED said, it's specific to the Prime Minister and Leader of the Opposition, those summaries that he signs.
Yeah, I really think, Mr. Chairman, with respect, the Integrity Commission is creating an issue where there is none. This section speaks to a summary declaration,
right?
And the full is obviously in contrast to the summary. That while a summary is published for the Prime Minister and the Leader of the Opposition, the Commission has received their full, or if they want to use complete, report. Now, as to the accuracy and the truth,
I agree with you,
that's something completely different, and I don't see how it could be interpreted to mean that the chairman of the commission is making an attestation as to the accuracy of a report given by somebody else. That's obviously not possible. So I don't think it could be interpreted in any way, shape, or form to mean that, because it would be ridiculous. So I think this seems to be, really just semantics, and I don't think it's a material point.
Chairman.
Yes.
Chairman.
Yes, Dr.
Could
Guy.
the commission point us to the area that speaks to a full declaration in the statute?
You want to point to the section?
Yes, because I'm looking at it. If I think it's 42, and I don't see the word full anywhere there unless I'm not reading properly.
Member, you may want to direct your attention to Part B of the ICA, the Integrity Commission Act, which sets out a summary of statutory declaration, which is the actual form for the summary. At the bottom,
look at page 61. Look at page 61 of the Act. I'm assuming the
61.
numbering that I have is the same as yours. Yes.
Yeah. If you do have the same number.
It says the Integrity Commission hereby certifies that the statutory declaration submitted by the declarant has been examined and is satisfied that a full declaration has been made in accordance with the provisions of the Act. And you want full to be substituted with what?
That, well, just removed to say that it is satisfied that a declaration has been made.
Or let us just
So it's really just
maybe
removing.
we should substitute it for complete, as Member Bunting says, because I'm of the same opinion.
Well, they can certify that they're complete. You see, that's the point they're making, that the chairman is unhappy, you know, because I think they're trying to go behind the declarant.
But Chair, if it is that a summary has been published, what this is certifying is that there is something beyond the summary, which is exactly what Member Bunting is saying, and I agree.
Chairman,
can I just make a point here, because we're talking about use of English. I'm looking at a dictionary and I'm looking at the word full. And this is what it says: complete, entire, whole, perfect, full, absolute, thorough. And, you know, with respect to our chairman and his position, what he's saying, he's not going to put his signature to this, because what he's attesting to is that a complete declaration has been made, and he can't possibly know that. And that's all we're saying. Perhaps you can find another word.
Mr. Christie, I appreciate the point that has been made, but this is coming after an examination of what has been submitted. I do share the view of Member Bunting that it does appear as if a problem is being created where none exists, because the picking apart of whether it is full and whether it is accurate does seem to me a little odd. But since it doesn't mean that questions may not arise as to whether the declaration is accurate, whether the declaration satisfies all of the provisions of the Act. But I get the point. I don't see any harm being done in saying that a declaration has been made, but it is in comparison to the summary. So, you know.
Yeah, I think it has to be read in that context.
Yes.
Points are all noted, Chair and honorable members, but as I said before,
declaration.
This is a considered recommendation of our commission, so it's something that we would have to go back to them with.
Remove the word full
Yes.
and
that's our recommendation, Chair.
Okay. All right. Continue then, Mr. Christie.
Yes, Chair. Thank you. The next item, which I'm going to ask Director Craig to speak on as well, but before he starts, I just want to make a point. It is speaking to amending the statutory declarations to have declarants provide particulars of what is called registrable interests. I just want to say something, that what we're asking for here is really nothing untoward. In other jurisdictions, this information is provided for public access. For example, in the Turks and Caicos Islands, where I served once, you have statutory declarations which are confidential. We can't release them to the public. And when we get to section 56, we're going to make it clear that those are matters that we won't regard as fully confidential. We are not interested in making that that sort of information public. But in a number of Commonwealth jurisdictions, in addition to a declarant making a statutory declaration, they're required to disclose what is called registrable interests. And those registrable interests are placed in a register, which is available for public scrutiny and public examination. The same regime obtains in the United Kingdom. It's a public document. We're not asking for this information to be placed in a public document, but to be placed in the statutory declaration, which remains confidential.
And this ask is only in relation to parliamentarians, not to everyone, not to everyone who is required to submit a statutory declaration. Only parliamentarians.
I will let Director Craig speak on that, Madam.
Yes.
Yes. Director Craig.
Yeah, thank you very much, Edie. The recommendation speaks specifically to parliamentarians because of the framework within which we examine. But I would have to clear the hurdle with the commissioners as it concerns extending it to other public officials. But it is something that I believe that we could also benefit from if it's extended to them also. But that would have to be cleared since the recommendation has stated
my concern right now is that the scheme of the law is that, with the exception of the leader of the opposition and the prime minister, for whom publications are made of the summary of their statutory declaration, everything else in the law applies to everyone equally.
Yes.
Yes.
But you now want to single out parliamentarians. You are now singling out parliamentarians that they must be required to make submission of an additional category of interest.
And that's exactly why I gave the prelude.
And the concern only relates to people who are part of the political directorate, parliamentarians.
And that's why I gave the prelude, Madam Member, that this is a regime which already obtains in several jurisdictions, and it is applicable only to parliamentarians. In the United Kingdom, it's applicable only to parliamentarians. TCI, where I was, just parliamentarians. But the point I'm trying to make
and I take it there is no issue of corruption with parliamentarians there.
No. What I'm going one step further is that what the Interior Commission of Jamaica is asking for is not even to treat this as a public matter, but just to have the information as part and parcel of the statutory declaration. It's kept confidential. Whereas in the other jurisdictions where this regime currently obtains, it's public information.
So why one branch of government and not all branches of government?
Well, as Director Craig pointed out, if it is desirable that
no, I'm not talking about the desire. I'm talking about the risk that's assessed. I need to hear what it is that the parliamentarians pose, the particular risk. I'm really asking, notwithstanding how my tone may come across, I'm really trying to because telling me that it exists in another jurisdiction without more is not a sufficient explanation for me.
Okay.
Given the scheme of the Jamaican law. So I just want to know why this category and not all or all of the branches of government.
Before you answer, Mr. Christie, I just want to piggyback on that because I want to support Minister Malahoo Fort's point. I would think, for example, that somebody who is a permanent secretary or a CEO who is actually, deciding on contracts and signing contracts of business, giving out contracts, they're having a beneficial interest in corporate bodies and government boards, etc., would be more useful in assisting the complex nature of corruption-related investigations. Parliamentarians tend, yes, they have influence, but have less direct connection than the operating officers of ministries, departments, and agencies. So I don't understand why it would be less desirable to assist corruption-related investigations, to not have those persons declare their various interests in corporate bodies, etc.
Further to that, there is also the process of, and I know that it's still work in progress, meaning the contract tendering process, the PIMSEC process, and all of those. I really am just befuddled as to why the singling out, given the goal that is to be achieved.
Fair enough, Madam Malahoo Fort and Member Bunting. Let me say this. Our job, one aspect of our job, as I indicated at the outset in my opening remarks, is that under the law, we're required to monitor current legislative and administrative practices in other jurisdictions around the world in the fight against corruption. and this is precisely what we're doing. We're looking at other jurisdictions to see what standards of accountability or transparency or disclosure that they require of public officials and various categories of public officials. This particular regime is a regime which has been developed specifically for parliamentarians. Why that is so, I don't know. I, for one, have absolutely no difficulty with the positions that you have put forward, that there's absolutely no reason why it should not obtain to other senior public officials.
And why recommend it in isolation?
I just answered that question, Mrs. Malavu Fort. I said that we are looking at other jurisdictions and regimes around the world. And that is what we're looking at. That's what others have, and that's what we're putting forward. I'm about to say that I personally would have no difficulty whatsoever as a senior public official making these disclosures. You have alluded to other categories of public officials, and that's a call for the parliament. As of now, what we're putting forward is what we have seen in other jurisdictions right here in the Commonwealth. And if it is that you believe that it should be extended to other categories of public officials, I do not think that the Integrity Commission would have a difficulty in saying yes. But again, I'd have to reserve my call on that because I'd have to consult with the Commission.
Through you, Chair. No, I'm not at all saying that it should go. I'm merely questioning why. And you've said it is because of what you have looked at. And the regime is particular to parliamentarians. May I also ask whether your assessment and evaluation reveal the improvement in combating corruption as a result of this category and this regime that is specific to parliamentarians? Whether the results show in particular the effect it has had in combating corruption and promoting integrity.
Yes, when you look at the mechanisms of Madam Malavu Fort, I think we have to look at the context that first and foremost, parliamentarians are our lawmakers. Parliamentarians, especially in our constitutional construct, are also the persons who constitute our executive. They're the ones who set policy. They're the ones who make decisions that affect everybody else in the country. And so it is quite appropriate for parliamentarians and politicians to be governed by higher standards of accountability and transparency than anybody else. That would be my comment. And so when we look at these regimes in other jurisdictions, it would not be surprising to me that you will see higher standards or stronger regimes of accountability for persons who hold these positions and other public officials. And that is not in any way to detract from the point that Senator Bunting made, that nothing would be wrong as well to have these standards applied to other public officials who are not parliamentarians.
Through you, Chair, just to make it abundantly clear that there is no divergence in view on my part about the higher standard to which those who exercise certain functions are to be held at all. There is none. But just to say that government is not limited to the political directorate. And as a matter of fact, I think we go down the wrong path in examining government without looking at who discharges what functions and who's responsible for what. Because after laws are made, they are not enforced, nor are they implemented by the political directorate. And there's a process by which law is made, and it doesn't, and it is not entirely left up to the parliamentarians, though the cabinet approves the policy and the parliament passes the law. There are processes that one goes through because government is much larger than the political directorate. A ministry is much bigger than the minister who's at the head of it. And I think while I understand to a certain point the issues around parliamentarians and politicians, I think by constantly putting the spotlight on those offices, we leave other offices in the dark. And the inefficiencies and corruption in government is not entirely attributed to the political directorate, simply because we have to look at who is responsible for what function, who does what. And so the Integrity Commission is about integrity in public life. And public life, to my mind, is much bigger than the political directorate. And the political directorate, and in particular parliamentarians, elected parliamentarians, go through a democratic process to get to office. But we will await the further information on it.
Member Bunting, you have a further contribution?
Yes, Mr. Chairman. In fact, as I'm thinking about it and listening to Mr. Christie saying about some persons must be held to a higher standard, it would seem to me that commissioners themselves and senior directors of the Integrity Commission should be held to the highest standard. And you know, I can't help but reflect on the omission in one of their recent reports, where they mentioned no conflict of interest of one of the commissioners who was and had an active role in one of the organizations they were reviewing, and there was no, to my recollection, declaration of a potential conflict of interest. And I think the Integrity Commission has to start with itself and its own commissioners and senior members in holding to this highest standard.
Chair, through you, Senator Bunting, I agree with you 1000%. Without equivocating on the point. I fully agree with you. And I've often said, I've said it in my introductory remarks before the Oversight Committee, that as, you know, members of the Integrity Commission, we have been entrusted with the responsibility to ensure the highest standards of probity, good governance, integrity across the Jamaica public sector. I say to my staff, every person who is shortlisted for a job in this institution, I have a discussion with them. And that's one of the things I discuss without exception, that we must therefore lead by example. We cannot expect to be saying to public officials, whether they be public servants, whether they be parliamentarians, whether it be, you know, whoever, whatever classification of public officials, that they must do this and they must do that when we are not doing the same thing. In fact, we have to bend our back, we have to bend backwards over to ensure that we hold ourselves to a higher count. So I fully agree with you, Mr. Bunting. I fully agree with you. I can tell you that in all the meetings that we have a board. As you know, we're required to meet at least 6 times every year. In the annual report, which was tabled in Parliament yesterday, you will see a full accounting of the board and the board committees, who constitute those committees, and how many times per year they meet. I can tell you that in every case, it's a standard item on the agenda, disclosure or declaration of conflict of interest. You know, the agenda is circulated, and you know, each member is asked to disclose at the very outset whether he or she believe that they would have a conflict of interest.
All right.
That disclosure is not made in the actual report. That disclosure is kept private.
No, I'm talking about proceedings of meetings. You are now talking about an investigation report, and I'm not sure which one you're talking about.
All right, but apart from that, Mr. Christie, looking back, I mean, you're asking for contracts with the government. Are you aware that every member of parliament, it has to be declared parliament? Why would you want this on an annual form? In other words, once a member of parliament, even if it is a company is involved with, as a contract with government, it is a basis for, I mean, expulsion from parliament if he fails to declare it. Are you saying that he must also declare it annually?
Chair, I am aware of that provision. I think I was the one as contractor general who developed a reporting regime for parliamentarians who have contracts with the government, because that's governed by the Constitution itself.
That's right. So
And
why would you
so
would you want that to be declared in your annual report?
Well, I'll ask Director Craig to answer this. And
no, before he answers, and then,
yes,
why would you want membership, say, of a professional organization? I mean, am I to declare every year that I have paid up my annual fee to the General Legal Counsel?
Again, Chair,
or to the Jamaica Bar Association?
Chair, I think what you're looking at here, as I said earlier, it is merely a replication of a regime which obtains elsewhere in the Commonwealth.
But that doesn't mean we should adopt it.
I didn't say that.
Exactly. But it is being proposed in the whole scale. So if it is being proposed, it means that it's being accepted as is without any kind of interrogation based on our environment.
Again, let me go back to the foundation of this. We're required to monitor current legislation and administrative practices in the fight against corruption and to bring them to your attention.
So this is just you bringing it to our attention here. We shouldn't have to consider it.
No, we're making a recommendation, Madam Holness. And, you know, if you...
Hamilton is
I see.
Hamilton.
Okay, I'm sorry. Member Hamilton, we're making a recommendation. And it's at the end of the day, it's your lawmakers decide whether or not they believe they want to accept.
But the issue here, you're indicating and recommending for us to adopt them. And we are asking you, why would you want to duplicate something that is already done by parliamentarians, declaring in the contract they have with Parliament? Just a second. Secondly, you want us to declare our beneficial interest in land. We have already declared all our interests in anything we have in terms of the present declaration. When you say the beneficial interest in land, obviously, if you are, you would have declared that on what is presently, provided for. And I mean, why would you want, if you're a trustee or beneficiary of a trust? First of all, if you're a beneficiary, you have to declare that in the present declaration. If you're a trustee, I suspect you would too. I mean, it just seems that some of these, what you're asking for additional declaration, Mr. Christie and Mr. Beresford, it's just making it burdensome for parliamentarians. It is already burdensome to make these declarations. And I get the feeling that you even want to make it even more burdensome. I mean, is it really necessary?
Director Craig, you want to answer the chairman?
Before Director Craig
Minister Malin,
comes
go
in.
ahead.
Right. Just to say, Minister Choke, my concern is not so much the burden as legitimate a concern that may be, because we have to devise systems that are administratively workable. I just want to address Mr. Christie's comment in response to Member Clover Hamilton that the commission is merely making the recommendation. It's not. It should be viewed as that, because I note the many reports in the media about the recommendations made regarding the so-called gag clause, and the message that is being conveyed is as if the parliamentarians have something to hide, which is why they are not willing to revisit the matter. No recommendation is to be taken lightly. Every recommendation made must be properly interrogated and considered against the backdrop of whether it will enhance the work that is to be done in the fight against corruption and the promotion of integrity in public life in particular. So I don't want it to be even misunderstood that we are going through a mere academic exercise, because the law requires the IC to make recommendation. The Parliament must also duly consider the recommendations.
Yes, Chair.
You wanted to respond?
Before Director Craig speaks, I think perhaps it's important that I just contextualize things. I think it was my colleague Selwyn Hay who spoke to this earlier. I know people have challenges with the views of Transparency International, but it is the world's leading and most respected anti-corruption watchdog or body. Jamaica is currently ranked as being a corrupt country. It's under 50, as you pointed out. It is up to all of us to find ways and means to strengthen the perception that something is being done to fight corruption. And there are many ways that this can be done. I have commented elsewhere that it starts with our lawmakers, because the lawmakers are the ones who basically set the anti-corruption legislative regime. If you have a weak anti-corruption legislative regime, or one that is perceived not to be strong, then it's going to be a debilitating factor in combating corruption. Also, if you have a weak anti-corruption legislative regime, then your institutional regime will be likewise impacted. You can't have a strong anti-corruption institutional regime operating on a weak anti-corruption legislative regime. So I think that's something that we all need to take into consideration. I remember addressing the Interior Commission last year on the issue of statutory declarations, and there were comments against, similar comments as to why you want to do this, why you want to do that. And we pointed out that, the whole concept of a statutory declaration is something which obtains in over 100 countries around the world. It's invasive, yes, but what it does, and we spoke about standards, if you want to become a member of public service, is something that is required. You have to declare your assets, income, and liabilities. That's going to be subject to scrutiny. And we have to file those returns. And if we are perceived as pushing back on it, then it's going to harm us. It's going to harm us because we're going to get a poor rating from Transparency International. And although some of us may have issues with Transparency International, the fact is that it is what the rest of the world looks at. It's what investors look at. And if a country is perceived to be chronically corrupt, and Jamaica has, I think we have averaged in the past 20 years, we have averaged a score of 38.7 out of 100, where 0 is perceived as being most corrupt and 100 least corrupt. We're under 50. You articulated what that perception means. We have to do something to really change that. And it starts with our lawmakers. It starts
with due respect, Mr. Chris.
Chairman, I'd like to weigh in.
Let me just respond very quickly. If legislation could create happiness, the whole country would be happy, And to say that legislation is going to be the mechanism by which we expose and stamp out corruption, even though the legislation could be as strong as you make it without effective, proper investigation and exposure of corruption, I'm not too sure the legislation is going to solve the problem of corruption.
I agree with you, Chair.
I agree with you. But so what I'm really saying is that you can make the legislation as strong and as invasive as possible. What is more important is, are we going to get from your body, the Integrity Commission, the necessary astute investigation to ensure that the corrupt in our society are not only exposed, but investigated properly and prosecuted?
Absolutely.
And I mean, to the best of my knowledge, that is where we should be focusing on. I'm not denying that we need a good legislation, but the point that we have been trying to figure out, why are you going into all these little areas? I mean, when you came before the Oversight Committee, one of the points I raised was, you wanted for us to declare what valuables we have in a safety deposit box. Not only is that invasive, but how are you going to verify that what we say is correct? First of all, you would need to ask, do you have a safety deposit box? And is that appropriate for a public official to say, yes, I have a safety deposit box? And then the next thing, what do you have in there? And I mean, there are certain things like that, just like we're asking these questions now, they're not only invasive, but inappropriate to put in a legislation. Minister Malalouford.
Thank you, Chairman. again, let me speak for myself firstly, and I will be presumptuous enough to speak for the team that I'm a part of. This government, led by Prime Minister Holness, is committed to doing all it can to fight corruption. It is true that we live in a culture that is permissive to corruption. What does not help in monitoring the perception about corruption is the statements being made by persons in high places, which are contrary to the facts. So let us look at what we have, since we are and what exactly the Parliament is doing. This law that we have replaced an old law, and it created a new paradigm in the fight against corruption. The model was promulgated as one which, if adopted, will go a long way in strengthening the work in the fight against corruption. It was adopted in the jurisdiction. Since then, the international community which recommended it has had cause to re-examine it and now questions whether it is the most effective model. And this is not too long after it was recommended as the model and adopted by the government of Jamaica across political administrations. So that is one thing. The law provides for a review to take place within a certain time. It is now taking place. In addition, the law provided for an oversight committee to be put in place. For this Commission of Parliament, it is in place and we have been meeting. And if those are not tangible demonstration of a commitment to improving what we have and should be put forward to assist the perception that the government of Jamaica and the jurisdiction of Jamaica is not as committed. On top of it, the Parliament approved a budget for the Integrity Commission that would make it fit for purpose. Hold on, Minister Chuck, let me say my piece, because I do not take kindly to any impression being given that some of us here are merely paying lip service to the work that we have committed ourselves to do.
No, I wanted to add, Minister Ford. I want to add that.
So let us talk up. Hold on, Minister Chuck. I crave your indulgence, Chairman. So let us talk about issues that will help to monitor the perception of corruption and which set of competing matters are being put forward to push us deeper in the hole. It is my hope that the process that we're going through now would be put forward as a demonstration of our commitment. The level of interrogation that is taking place surely means that we are seeking to better understand if the goals are to be met, since it is clear that we are operating in a context of distrust all around. And when I said earlier that one of the critical governance questions that we will have to grapple with is the interplay between the elected and the unelected in a democracy where democracy is championed as the best and highest form of government in spite of all of the problems with it.
All right, thanks, Minister Ford. And I just want to add, to the best of my knowledge, Mr. Christie, everything that the Integrity Commission has asked of the Minister of Finance, increased numbers, staff, whatever you have asked, to the best of my knowledge, you have got it, because the cabinet wants to strengthen the Integrity Commission.
Absolutely.
In its fight against corruption. To the best of my knowledge, your budget is either close or over $1 billion per year. And you and I have a discussion where I think the commission, should they really want to expose corruption, is to use that Protected Disclosure Act. And it's a pity it's not it's a separate joint select committee. But there is where I would like to strengthen so that Jamaicans can expose the corrupt in our society. So you know, don't ever get the impression that we're trying to, by asking these questions, to restrict your investigation. I would want to see more investigation. So for the corrupt to be exposed, right?
Chairman, thank you, Chairman. And I just want to respond very briefly to the comments you've made, and before you, the comments that Mrs. Malahoo Ford made. I on every opportunity I've had to make an official statement, I have acknowledged without exception the support that the Integrity Commission has gotten from the Finance Ministry and by extension the government of Jamaica in support of its staffing needs and its budgetary needs.
Absolutely.
The report that was tabled in the Parliament yesterday, I have a statement in that report. And when you have time, you could look to see what I said. But I again acknowledge that support. And I thanked the Financial Secretary, her deputies, senior officials in the ministry, and I thank the Portfolio Minister, and I thank the government for the support that they have extended to us. They've always been positive. That's the institute.
I think that is important, you know, Mr. Christie.
And I keep, and this is what I'm saying, I have acknowledged it. So that's not something we're debating. And it's not the first time. Every opportunity I get, I acknowledge it. That's the institutional framework. That's where the government of Jamaica has unquestionably supported the Integrity Commission in terms of its staffing and resource needs. That's one aspect of the mechanism to fight corruption. The other aspect, though, Chair and honorable members, is ensuring that you have a strong anti-corruption legislative framework. And that is what we're now talking about. Section 60, which requires us to constantly look at the legislative framework. You know, we're looking at the Integrity Commission Act, and to ensure that we review it at least once. Well, the first review must take place in the first 5 years. And that's what we're doing.
Mr. Christie, that is the point. There must be balance. There must be balance.
Let me just finish my point here. And this is not me who is about to say this or you. This is an independent entity who is looking on 180 countries around the world that has made this comment. This is what Transparency International said about Jamaica in January 22 this year in its official report that everybody else has seen, including potential investors. This is what it said. Jamaica has been struggling, and I'm quoting verbatim. Jamaica has been struggling for several years. It has made some progress. However, this has come alongside significant resistance to anti-corruption reforms from many politicians in the country. Those are not my words. Those are the words of Transparency International. And all I'm saying, Chair and honorable members, is that this is something that you and us have to take notice of. And we, having read this and take notice of it, we recognize that we must now respond to our functions, our mandates under the Act, to come to you to say, okay, what is it that we need to ask you to do to make this perception go away? And that's the only point I'm trying to make.
No,
and I want to make one more point.
I don't know where they could make that comment.
Well, that's not for me. That's not for me. That's for Transparency International.
But let me make the point, you see, because, you know, the public at large must know, speaking for myself and the cabinet that I sit on, and you have made presentations to the cabinet, right? You and your team. We are determined as a country to wipe out corruption. Now, the point that we're making is that some of what you're requesting, even here in this presentation, the only thing that is left for you to put in the legislation is for the Integrity Commission to visit the home of a parliamentarian at least once per year and check out what he has in his house or what he has improved his belongings from the previous year. Because if you're going to ask questions like security, if they have what is in the security box, how much improvements have you made to your house in the past year, then the only thing that is left is for the Integrity Commission to ask us to put in the legislation that once per year you can visit a parliamentarian's home to investigate. Senator Scott Martin. Senator Scott Martin, you had your hand up.
Thank you very much, Chairman. I'm trying to get my video on. I want to say that there has to be a balance in how we approach everything.
Absolutely.
And I am concerned that we are getting some recommendations which, although they might be present in other legislation in other jurisdictions, let me single out one. our constitution provides that if we have a contract with the government, we must so declare. And parliamentarians have been declaring it. There are consequences if you fail to do so. So to ask for it to be in this legislation now, because it is being done elsewhere, exactly. I think I'm very concerned about it. I do believe that the record, the scale of Transparency International is important, but I do not think we must go overboard when we are looking at this. And there has to be a kind of approach that meets the objectives which we seek to serve, which is to strengthen the perception of trust in the parliamentarians and to demonstrate the integrity of the parliamentarians. So I want to make that point firstly. I also want to make a point which I hope will be contemplated, because as you say, Minister, these reports are burdensome, they're highly invasive, and if we continue to implement more and more things which do not really enhance the requirements, which really do not take this anti-corruption move any further, what we will do is that we will exclude people who have integrity from entering into this space. Exactly. So I want us to consider everything when we are looking at the review of this legislation and the amendments which ought to be made. Thank you, Chair.
Thanks, Senator Scott.
Chairman.
Minister Ford, you wanted to add some more?
Yes, I totally share the view.
No, before you do, I think Ms. Hamilton was before you, if you don't mind now.
I don't
Mr.
mind.
Hamilton, and then you, and afterwards you, Minister Ford.
Yes, Chair, thank you very much. And I'm really endorsing what Senator Scott Motley just said. As a young parliamentarian, I find it a bit concerning that, from my view, the narrative from what I'm getting here is that corruption exists almost whole scale within parliamentarians. And that's the impression I get, or I'm left with when we're reviewing this legislation here. And from my understanding and observation as to what is happening within the country, it's endemic. So if it is that we want to really address corruption, we can't just limit it to one particular set of people. We have to go wide scale. We have to say, okay, if it is that this particular requirement is being placed, or Transparency International is making this recommendation, we interrogate it and we make it fit for purpose for our local consumption to say, okay, the entire set of persons who are supposed to declare this particular, make this particular declaration. It, as Senator said, it really discourages persons who want to serve from serving when we are exposed in this vacuum here as parliamentarians to have to now go and make these kinds of declarations singly. Make it wide scale. If it is that you're coming with a recommendation to say Transparency International has this perception, make it whole scale, make it wide. Make it for everybody wanting to be a part of government and governance to have this as something that they must adhere to. Why should just parliamentarians be subjected to it? Because Transparency International says so? That's my concern, Chair. I thought we were here to look at corruption on a broader scale, but I feel as though it was being targeted.
Well, definitely it's been targeted against parliamentarians, as Minister Ford said earlier. Anyway, Minister Ford.
Thank you, Chairman. Let me clarify again. The work that is before us is serious work. And it is true that Jamaica has been bedeviled by perceived and actual acts of corruption. But let me just go through the perception and a quote made by Mr. Christie. There is a certain methodology that is used in measuring perception. And that statement that was quoted didn't just happen to be in Transparency International country report on Jamaica just like that. It is as a result of comments made by particular persons whose words are being taken. And I know among parliamentarians, there is a tendency for each side to trade insults against the other. And so if you look on the conduct of parliamentarians themselves, especially when the campaign season comes around, part of the practice of politics is to levy accusations against each other. And very often, the proof that is required to substantiate the accusations are not forthcoming, right? And it is part of, it's not unique to Jamaica. We have examples of it all over. But beyond that, there are persons, especially, where they go out and they make report. When I listen to the media report leading up to this morning's committee meeting about the recommendations made in respect of the gag clause and the reluctance of parliamentarians to deal with it, the message that is being conveyed is that we are all so darn corrupt that we really have not a clue and we have no interest in taking steps that would combat corruption when they involve legislative steps. And I take serious umbrage to it, speaking for myself. I really take umbrage to it. So the report, it is not, it is somewhat, I find it curious, given the methodology used by Transparency International to report on countries and the exact nature of that comment that is quoted, how much it replicates and mirrors the comments being made in certain quarters. So we can't put up our hands and say it's not me, because many of us are quite au fait with the methodology used in measuring perception and how comments get into reports, which then paint a picture of a country. And some of us are also very aware of how uneven the hand is, because there is no single country that is not dogged by perceptions. So if we, having taken on a model that was presented to Jamaica and the rest of the Commonwealth as one, if adopted, would go such a long way in strengthening it. And if we have put review mechanisms in it, and we're actually doing it, because this is much better than other pieces of legislation which have provided for review, we're actually doing it in time. Right. And we're now interrogating. If we have, hold on, Minister, if the government has said no greater indication of priority is there than your budget, and it has appropriated the funds required, and has also approved the model where you can get your other appropriations in aid through your donations, I'm kind of at a loss, because we're simply interrogating whether recommendations are going to inure to the benefit and will enable us to achieve the goal. Because there's a lot of lesson to learn, In a country where the culture is as it is, we talk about education need, but then we are reluctant to wait it out because culture doesn't change overnight.
All right, thanks, Minister Ford. Now, Mr. Christie, if you don't mind, there were two other contributors who are here. I think they're on the, and I know the Integrity Commission should be at all of our meetings. Do you mind if we break you here? And then at the next session, you continue? I mean, so we can take these two presentations from JAMP, Jamaica Accountability Meter Portal, and Jamaica Lands, and then we continue with you at the next session, Mr. Christie, because sure, I think you will be here throughout.
If I may, Chair, could I ask you to just allow us 15 minutes to wrap it up, to overview what we have?
It's just that we have to stop by about 1 o'clock, you see.
If you give us 15 minutes, Chair, we will wrap it up in 15 minutes to overview what.
And then if members don't mind, any further questions will put off until the next meeting, yes. So we can get LAMP and JAMP to make their presentation. Okay. Try and make it 10 minutes, 10 minutes.
Thank you very much. I'll just go to item number 5. On the item number 4, disclosure of registrable interest, the only comment I want to make is that that recommendation would consolidate all the information in one place on the statutory declaration. I will ask Director Craig to just go to gifts to parliamentarians. Director Craig, a brief comment.
Thank you very much, Edie, and through you, Chair. Yes. The only thing I'd like to add with respect to disclosure of registered interest is that I've noted the comments, and what I'm hearing is that, you know, it's something that probably should be extended. We will have to deliberate on that, but I believe it's a very great recommendation. So let me move to give parliamentarians, public officials from relatives. What we're asking is that 44 be struck out, because we're of the view that it creates a loophole and that has the potential to be a corruption enabler. But the previous presenter from the FIE, CTD, he would have indicated that the entire provision should be struck out. But in the first instance, as we are concerned, we are recommended that the last provision, which is 44, be struck. Thank you very much.
Thank you, Director Craig. We're now going to come to recommendation number 6, Chair. And that is, I think, was touched upon by our colleague Selwyn Hay from FID, and it's to include an offense in the Integrity Commission Act, which we had in the Contractor General Act. I'll ask our Director of Investigation, Kevin Stevenson, to make a brief comment on it. Director Kevin.
Thank you, Executive Director. Good afternoon, Chairman and members of the committee. As you indicated earlier, Mr. Christie, this recommendation was alluded to by Mr. Hay earlier in his presentation. But just to give some background to this, there are 2 ways of requesting information in the course of of my duties as Director of Investigation. There is 1, the request for general information about contract, prescribed licenses, etc. And there is also the request for information in the course of an official investigation. The matter having to do with a request for information in respect of official investigation is properly treated with under the statute, as when information is requested in the course of an investigation, it is not provided, then there is an offense treating with that particular course. But under Section 51, there is a scheme whereby the Commission, through the Director of Investigation, may request that public bodies provide information about contracts and prescribed licenses, etc. In this course, if the entities do not provide the information that is requested, and we usually do this by way of our quarterly contract award report and the annual contract cost overrun and variation reports. If the entities do not provide this information, there is no offense that they would have committed, which would allow for us to enforce that provision in respect of the requests for information. And this information is a significant tool for us in terms of our risk assessment, and it also supports a lot of our investigative activities in respect of contracts and prescribed licenses. We intend, of course, just to say that in respect of the QCA, there are 2 concerns there, but I must say firstly that there is a high compliance rate in respect of the QCA. But there are times when entities may fail to provide the information in the manner that is prescribed by the Commission. And there is really, other than moral persuasion, there is nothing much that we can do in respect of same. And in respect of the annual contract cost overrun and variation reports, there are times, well, currently we have a very low compliance rate. I think it's below 40% at the minute. And we have annually a challenge in getting entities to provide this information.
But at the end of the day, there is nothing in terms of an offense that we could charge them with if they fail to provide the information. There's no penalty for failing to provide the information. So we'd like for that to be addressed in the same way that we address a situation where information is requested in the course of an investigation, or where information is requested by the Director of Information and Complaints under Section 43(1)(b) of the Integrity Commission Act. I think that sums up our recommendation in that regard.
May I just ask Mr. Stevenson, to the best of my knowledge, Mr. Stevenson, when you ask for additional information from a parliamentarian, don't you normally get it?
In the course of an investigation, yes, Chairman.
So why would you want to make it into a criminal offense? Because you give them time, and if they refuse to answer, it is an offense already. So why would you want to put an additional criminal offense?
Chairman, if I may, I would like to steer the discussion away from parliamentarians, because a lot of the cases that I do in respect of contract do not involve any parliamentarian. Oh. So, and in any event, the requested information, the cause that I would have to request information from parliamentarians would be under the second scheme that I suggested earlier, whereby if they fail to provide the information, it is already a criminal offense.
That is correct.
That is not in dispute, and that is not the recommendation that is being made. The recommendation that is being made is when we request, for example, for public bodies to submit information in respect of the award of contracts and the issuance of prescribed licenses, there is no offense that is created should they fail to comply with such a request by the Commission. So that is the recommendation that is being made.
Okay, any comments?
Just to say,
Chairman.
Chairman.
Senator Golden, if you don't mind, Minister for letter, and then
I will defer to Senator Golding. She hasn't spoken before, and then I will come back in.
Go ahead, Senator Golden, then Guy. You're not coming across well.
Are you not hearing me?
Go ahead.
All right. If I could just inquire into the what was just said just now. I am not understanding a request from public bodies to provide information in relation to government contracts. Isn't one a request of any public body as it regards that kind of information that is not exempt and must be disclosed under the Access to Information Act by anybody requesting that information, one. And two, is the Integrity Commission suggesting that a delay or a failure, and I use those two words because quite often we have a situation where public bodies do not respond to requests in a timely fashion, and there are provisions on the Access to Information Act that extend time to public bodies to respond. But are you suggesting that we're going to now be criminalizing public bodies? And if we are criminalizing public bodies for that failure, who exactly is going to pay the penalty in that offense? Is that going to be the chairman of the board? Is that going to be the managing director of the public body? How does this work?
Okay, if I may, Chair, just to Chairman, to offer some clarity. The member Golden is breaking up.
I hope I was heard.
I heard most of what you said. I think sufficiently to respond. So yes, to your first point, there is under Section 48, when information is requested, there is no bar to providing the information to the Commission. So the excuse of the information being held or being protected by secrecy legislation is not a bar to the Integrity Commission receiving the information. But if I may reiterate the point that was made earlier, this is only in the course of an investigation. But the Act under 51
So such information would be requested in the course of an investigation under 48. But the provision that I'm making reference to in respect of the recommendation for an offense to be created is the provision under 51, where public bodies are required to advise the director of investigation of the award of contracts, as well as the issuance, variation, termination of prescribed licenses, etc. So there is that requirement. And I'm not sure if you are familiar with the QCA report that public bodies normally submit on a quarterly basis, a report of all contracts awarded over the quarter above a value of $500,000. And we will move in short order to request similar information for licenses, etc. When they fail to provide the information—
Mr. Stevenson, allow me to interrupt you. Allow me to interrupt you, please. My question is contextualized around the quality of the information that you're requesting, because the information that you are referring to is public information. It's not non-disclosable information. It's not exempt from disclosure. If a radio station wants to know about a contract given to somebody by a public body, they write the public body under the ATI and they request information. Now, unless it falls under certain exemptions of the ATI, they should get that information. So the Integrity Commission is not barred by those exemptions, is what I understand you to be saying. And I don't have a difficulty with that. I'm trying to understand, if you're not barred and there are already offenses under the Integrity Commission Act that punish someone who does not respond to you within this stipulated time, as it relates to public bodies, who are you going to punish? I want to get to the who, because as chairman of public boards and as a member of a public board myself, when a managing director doesn't respond to your request, which I may not know at the board level at the particular time, am I going to be held accountable for that? Is a managing director going to be held accountable for that? How are you going to, I want to understand how this is going to work.
Okay, so if I may respond, Member Golden. Again, we are not disputing the fact that the information that is being requested, that the Integrity Commission is entitled to receive that information. In fact, the Act makes very clear provisions in respect of information, in respect of contracts, government contracts, as well as information in respect of prescribed licenses, etc. We have the authority to request that information. And of course, the public bodies have a duty to hand over the information. But we request this information in two ways. One, the information may be requested in the course of an investigation. And that is done under Section 48. And if they don't hand over the information under 48 without any excuse, etc., and of course there are exceptions in respect of attorney-client privilege, etc., and other matters having to do with national security, then they can be charged with an offense of failing to hand over the information to the Integrity Commission. However, there's a second way in which we request the information, and this is under Section 51, which creates a duty on the part of public bodies to submit to the Director of Investigation information in respect of the award of contracts, prescribed licenses, etc. And to your second question in respect of who would be liable if they fail to hand over the information, then it would be the accounting officer who would be liable for failing to hand over the information under the PBM.
Yes, Minister Port, go ahead.
All right, so I appreciate the concern that is raised here on the failure to provide information when requested. I think it's a general problem across government. it almost appears in some instances that those who are discharging the functions of office take umbrage to being asked to account for things. I am not sure if the solution is to create another offense, and it wouldn't necessarily be my first point of trying to resolve it. This is point, Mr. Stevenson, just remind me, this is what number recommendation?
That is recommendation 6, Minister.
Recommendation 6. So, the director, right. There is a way to get information. So my general concern is about duplication of processes and whether we are, not every matter is going to fall under the Integrity Commission Act in terms of what needs to be done. It sets the framework and not every thing. Have you, in the instances where you've had difficulty, written to the financial secretary of the Ministry of Finance to seek assistance in getting the information in respect of, because awards of contract licenses are all matters that relate to the financial state of the public body. You know, it is matters for which they have to account on a financial basis. Have you ever sought that route, or is it the approach of the Commission to operate squarely within the Integrity Commission Act itself? I mean, do you look at where other provisions of law? So we do have a Public Bodies Management and Accountability Act, which sets out certain things that public bodies are required to be held accountable for.
So, to your point, Minister Ford, we have taken all the necessary steps, including writing to the permanent secretaries. If it's a matter that has anything to do with the financial secretary, we've written to the financial secretary. But this is, as I indicated earlier, is routine information having to do with the award of contracts. And what we require of public bodies that they inform us by way of the QCA.
And these are contracts above threshold. So, you know, Ministry paper sets out contracts that are awarded. I mean, I'm just to follow up a little on I think the point made by Senator Golding. Are you saying that you have exhausted every possible avenue to get to the information and without success?
Well, I would not say so, because I could not say that we have done every single action that is foreseeable in order to get the information. The fact of the matter is that we send reminders very often to public bodies who have reports outstanding. And it's particularly in respect of the annual contract cost overrun and variation reports, that some of these reports are outstanding for 2-3 years. We make contact with the head of entity, and often the reports still remain outstanding. We have started writing to the heads of entities, having identified the reports that are outstanding. We write to the head of the entities and ask them to submit the report. And of course, just to communicate with us whether or not they're having any challenges in supplying the information. Not only do public bodies just disregard from time to time the request of the commission, but there are times when they just refuse to hand over the information, and there is really nothing, short of asking again, there is really nothing that we can do to get the information. So that is why the recommendation is being made here. And
so
I say that, sorry, Minister, last year, in the last quarter, over 6,000 contracts were awarded. And those are contracts that were reported to us. To ask the financial secretary, let us say 5 or so ministries failed to hand over the information. To ask the financial secretary to have that information, to collate that information and hand it over to us, I would imagine would be a very difficult task to get all of those contracts put together and then handed over to the Integrity Commission. I think it's important to understand that there is a responsibility on the part of the head of entity to keep proper record of these contracts, prescribed licenses, etc., and then to submit the information to the Integrity Commission in line with the provisions under 51. And insofar as we have had the opportunity, we have provided the necessary support. There are times when we reopen the portal so that entities can enter the information at a late stage, because after a certain time, the portal is closed. But we, as I've said earlier, we have not always been successful in getting all the entities to submit the information, particularly in the area of the annual contract cost overruns and variation, which I think is an area that is of high risk that we need to interrogate. And in order to interrogate, we must have the information before us.
So I have to tell you that I am very sympathetic to this, because it is true that this is an area that requires close monitoring, and we have ample example of the disregard by public entities and this, scant regard, disregard the approach that is taken. Bear in mind that the government has taken a massive step in the accountability framework for the management of boards of public bodies. Massive move, total restructuring with the regulations that were passed. So action has already been taken to address matters around the conduct of boards, board chairmen, and both at the personal level and at the corporate level. And I do believe that once fully operationalized, we should see some benefits. But for my part, I'm very sympathetic, because I think you are correct that this is an area where there is a high level of risk which needs to be monitored. Still uncertain whether I would want.
Minister Ford, it is something we would give some further consideration.
Yes, I believe it should be deeply considered. I'm not yet persuaded whether it's by way of an offense, but something has to be done in this regard, bearing in mind that a major step has already been made with those regulations that have been promulgated around board management and the entire accountability framework.
Okay.
Chairman, if I could perhaps just lend some assistance to the committee to put this into perspective. What we're asking for is not really a new offense. The offense we're asking for is actually on the statute books here in Jamaica for over 30 years under the Contractor General Act. Identical matter that we're talking to. And I'll just read it very quickly for you. It says, every person who willfully makes any false statement to mislead or misleads or attempts to mislead a contractor general or any other person in the execution of his functions under this act, or without lawful justification or excuse obstructs, hinders, or resists a contractor general or any other person in the execution of his functions under this act, or fails to comply with the lawful requirement of a contractor general or any other person in this act, commits a criminal offense. As you know, the Integrity Commission has subsumed the functions, roles, and authority of the contractor general. Those functions are now vested in Mr. Stevenson in his capacity as the Director of Investigation of the Integrity Commission. So all we're really asking for is to give him the powers that his predecessors under the Contractor General Act had. That's all there is to it. It's nothing new. It's the exact offenses that existed since 1988. And
All
they're
right.
not now an Integrity Commission Act.
Mr. Christie, can we ask now for you to suspend until we return, so at least give one other presenter the opportunity to make their presentation today? Would that be okay?
If you so desire, Chair,
Please,
as I said, we would have
you're likely to be with us until the end, right?
No, it's up to you. We would just take 5 minutes overview, but it's the questions that are coming that we are responding to.
Sure. So, but what I'm really saying, if we suspend your presentation now, and you will definitely be returning, and if not all the presentations, but to give the other presenters who we had invited this morning. I don't know if Ms. Caller, are you on now? Ms. Caller, are you on now?
My apologies, Chair. Yes, I am on now.
You have about 15 minutes to highlight your presentation. Could you please proceed?
Thank you, Chair. My apologies for the difficulties in appearing earlier. Let me just hit my share screen button. Well, good afternoon. I think it's afternoon. Good afternoon, committee. Good afternoon, Chair, and good afternoon to all of our listeners, the public on our PBCJ channels. JAMP is really grateful for this opportunity. I know we are referred to oftentimes as an anti-corruption civil society group, but truth be told, we do prefer to see ourselves as a pro-accountability group, because we think accountability certainly goes wider than the matter of corruption, but that is one of which we see ourselves as not combative with government, but partners. And the Integrity Commission certainly is chief among two in which we interact with most. So our presentation today is really hoping to give the committee hopefully a different lens to look at this act from, because it's a citizen's approach and not so much a government approach. And we've had the benefit of listening to two public officials before. And so we're hoping that this will add some value. With the 15 minutes that I have been granted, we really want to just take a look at 5 points that we want to make. It's the matter of 53.3, naturally, that has been the subject of a lot of discussion over the years. Interestingly, 36.1, it's a matter that was raised in the, I think, the October 2021 Oversight Committee of the Integrity Commission that I'd like to shine some attention on. And then I'd like to jump into 56.1. It's not one that the public knows much about, but I've been saying quite a bit on media that we have two gag clauses, and I think 56.1 is potentially more concerning than the 53.3 that we have been discussing. Would like to look at 42, very briefly at 42.3b, a matter of statutory declarations, and the matter of conflict of interest that we, particularly last year, had seen so many instances of, which we don't think is sufficiently addressed in the legislation. We'd like to share with you what we think could be done to strengthen it. So before I go any further, Chair, I really want to say that all my years in advocacy, I have often heard advocates indicate that the review of legislation is not really something that happens when it is supposed to happen, and it's something that they do spend a lot of time advocating for. So JAMP really wants to just acknowledge the work of the Parliament, not only in giving us this legislation, but the fact that we're here on time in the 5-year window to see what we can do to strengthen and improve a piece of legislation that has really been a game changer. So starting with the matter of section 53.3, which most of us are familiar with, but I want to say, particularly for those who are watching online, it speaks to until the tabling in Parliament of a report under section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of an investigation. We started our submission by looking at what did the Act have to say in terms of what are its objectives, what is it trying to achieve. And we thought it was important to look at section 3D because we have an Act that sets out what it wants to do, what its mission is. And JAMP is of the view, after 3 years of existence in looking at this Act and having challenges, we think that there's a contradiction here. Section 3D clearly states that it is to enhance public confidence and that acts of corruption and impropriety committed by persons exercising public functions, note, will be appropriately investigated and dealt with in a manner that achieves transparency, accountability, and fairness. So it sets out making the public here the focus. I think that we have heard quite a bit, I'm sure you have as parliamentarians, different viewpoints as to whether or not the idea that we need to wait until reports are tabled to know what is happening. We are on the side of believing that that doesn't augur well for transparency. We don't think it augurs well for accountability either. Oftentimes when matters come up, whether by the media, by another state watchdog agency, the public is left wondering what is happening to that. And oftentimes that speculation doesn't augur well for good governance. They're often left thinking nothing is happening. And so in terms of accountability, it becomes very difficult. And I think that's the key part of accountability, knowing what's happening, when it is happening, and why it is happening. Another object of the Act in Section 3B speaks to promoting and strengthening measures for the prevention, detection, investigation, and the prosecution of acts of corruption. Here again, I think in our submission, we refer to the Jamaica Constabulary Force and the extent to which they themselves and Crime Stop and so many other arms of government encourage citizens. I think the Auditor General is a prime example of her report speaking to the fact that the whistleblowing for her department has increased, I think, 500%. If my math is correct, it has moved from 6 to 34 public servants bringing information to her. That is what aids and abets in detection and in investigation. And certainly, if that is hindered, it's going to prevent prosecution. Now, what we have realized, and I want to share with the committee, is that in the 3 years that we've been around, in the last 2 years, we've had 3 public servants approach us with information that they would like us to pass on to watchdog agencies. The second one, I recall, was very clear that they wanted it to be sent to MOCA. They weren't comfortable doing it themselves, and we're really glad to know that if that is the case, that we can stand in the gap on their behalf. But the last one that came in that I want to share with the committee was very clear that they did not want to send it to the Integrity Commission. And when I inquired why, it had to do with the fact that he had additional information, but he wasn't prepared to share it until he knew that the entity was actually moving with it. And he was clear as a senior director in government that he would not have the benefit of knowing if the Integrity Commission is doing anything. And so to that end, he wasn't prepared to share. So that's just one literal example of what we are confronted with citizens who want to share, but come up against this restriction on the Integrity Commission and is actually hindering and hampering their decision, their desire to do so. Now, what is interesting, and I think we share this in our submission, is that while we have this situation dealing with one state watchdog entity, we have others who not only share with us and provide the public with the reassurance when we have these concerns around corruption and mismanagement, but one of the latest really was the Minister of Finance himself in the Parliament, reassuring the Parliament and the public that here was a matter pertaining to the Clarendon alumina production had been fully ventilated in the public space. I think it was brought to our attention by the media, but he was rightfully assuring us that the Auditor General would be doing the probe. Now, have we heard anything? No, we haven't. Does the Auditor General tend to come out and say anything? No, they don't. But what the public has is the assurance that something is going to be done. And I just highlighted here that this was not just the media, but it was actually coming from the Parliament as it relates to another watchdog agency. And JAMP doesn't fully understand why it would apply to one and not the other. Quickly, one function of the Commission outside of the object says that they're going to take the necessary and effective measures for the prevention and detection of corruption and it's pretty much in the same vein as the objects. We're just indicating yet again that under the functions, we find that there's a contradiction of sorts. Now, Section 36 speaks to the reports of the Commission, and it says here that the Commission may at any time submit a report relating to any particular matter which, in the opinion of the Commission, requires the special attention of Parliament. Now, how we read it at JAMP is that the legislators had created an opportunity that if the need arises, it says it's a special attention, and it kind of lends itself to believing that this would not be the norm. This would have to be if there was something irregular, something urgent, that the Integrity Commission needed to tell our parliamentarians that they provided that. And I thought that was great. But what is interesting, what I want to share with the committee and the listeners is the October 14, 2021 Parliamentary Oversight Committee discussion brought some, I would say, some great understanding of what is possible. And I'm just going to quote what was said here and then I'll comment on it. We had member Chuck, who was a member at the time, saying that the aim, referring to why they had this restriction on disclosure, the aim was to stop frivolous allegations. And he said, but once you have reported to the Parliament, that is the Commission, in the report, you can say that X allegation is now being investigated. He indicated that he didn't think anything was wrong with reporting to the Parliament that the allegation that was made is now under investigation. And then interestingly, Member Chuck said, you seem almost bound to not reveal anything. He then commented that on a monthly basis, you, the Integrity Commission, can tell Parliament what matters you have initiated in the last month. And if you table at the beginning of every month, that would clear up any doubts that you're not doing anything, which was a concern the executive director was expressing to the committee. So he concludes by saying, so table in the parliament that you have initiated these matters under investigation. So the entire team at JAMP were almost applauding because we thought, this is fantastic. Here is a member of the committee indicating that there is, and forgive the term, but almost like a loophole that would facilitate the Integrity Commission providing on a monthly basis information to the Parliament. And as we know, if it's in the Parliament, we're fortunate in Jamaica that we actually have almost a broadcast of everything taking place. So therefore, it would be in the public domain. So I noted that it went on. It wasn't just Member Chuck, but Member Robinson continued, and he offered up that the Integrity Commission should be in a position to indicate that they have initiated an investigation and that the only thing that they should say publicly after that is basically the time frame for completion, which we endorse, because at the heart of accountability is not just knowing it's happening, but knowing when it's going to be delivered to the people of Jamaica. And he closed off by saying it is important for public confidence that people know if an investigation has started or not. So the reason I've raised that is that I thought it was really important to share it with the committee. I believe there are a number of members here who are also on the Oversight Committee, that what the people of Jamaica was hearing is that, in effect, once the Commission has done enough to establish that they're moved beyond allegation and that there is some substance to the complaint and that there is an investigation, that we actually have in 36.3 a way in which they can feel free to communicate it on a monthly basis to the Parliament and therefore to the people of Jamaica. So it seemed to me that the members who have been entrusted to oversee the committee didn't, after all, or should I say, what the people of Jamaica and certainly JAMP was led to understand was not necessarily the case. So I make the point that what we would like to see, however, is if that is possible, and I have no reason to doubt Member Chuck and Member Robinson's view of it, but if that is really possible, and I didn't hear any counter from any of the other members, then it would be good to not leave it to what seems like a loophole in Section 36, but to strengthen that idea that once we have entrusted the Commission, as we should, to determine that it has been elevated to a place where they can substantiate the need for an investigation, then it is in the best interest of the company, I'm sorry, for the country, for us to be told. So what's JAM's recommendation? We wrap that up with the idea that the concern that parliamentarians have is legitimate. I have had the pleasure of serving on the sector committee for the National Contracts Commission while in government, and I want to say that the work of Greg Christie as the Contractor General is really and truly, while as a public servant, what pulled me in to the whole interest of corruption and governance. But the issue and the concern of the Contractor General then is one that we as citizens have only seen raised and pointed at one agency. So JAMP is saying to our parliamentarians, if we have so many other state watchdog agencies that have managed to be entrusted to operate in a way that doesn't see us being concerned about the damage, the unnecessary potential damage to the, not just to the reputation of parliamentarians, but to the business sector, then if it is limited to one agency and that agency no longer exists, and it doesn't, what the government or what the Parliament of Jamaica has done is provided us with I would say, an almost entirely different agency, meaning I have heard Mr. Christie said in the oversight committees and have acknowledged the extent to which there is no lack in terms of the resources. Whatever they've wanted, they have received. And so we have an agency with people who are well qualified, well paid, I hope. And I believe with that should come an increase in the performance. That should give us reason to believe that this agency, especially because we've ventilated this concern for the last 3 years, would act in accordance, or rather would not act in a way which would create that mischief or that nuisance that our parliamentarians were concerned about. The confidentiality clause, we believe, can hinder citizen support, and we've spoken to that. Deter detection, and therefore impact prosecution. We believe it hinders holding the Integrity Commission accountable, and this too we have heard Mr. Christie himself speak to in the Oversight Committee, that they are expecting that they're not the only ones who should be holding other entities to account, but they themselves need to be held to account, not just by the Parliament, but by the people of Jamaica. And how can we do that if we're not getting the information that we need? And last here, we are not suggesting that JAMP did an exhaustive search, and I'm hoping that there are others who will speak to it. But so far, we have not been able to find any jurisdiction that saw fit to create what Jamaica has called this gag clause. And therefore, if they can operate without it, and our other agencies here can operate without it, we don't see any reason why we shouldn't entrust the Integrity Commission with a similar environment. So we are asking for the provision for the Commission to, at a minimum, advise on matters that are being investigated. I often refer to the Robert Mueller case, where the entire world was aware of the concern regarding the elections in America, and we were aware, so were the Americans, that the matter was being investigated. But Mr. Mueller never said anything until we saw people who were being indicted coming into the news. That's exactly what I think at a minimum the people of Jamaica deserve, to have the reassurance that, and I don't mean this in a vulgar way, but to have the reassurance that the $1.15 billion that more than likely they are financing the majority of it, that they are getting value for money. And part of it is information transparency in order to hold them to account. Now, regarding the privilege and confidentiality clause, I want to look back at it because 56.1, and I'd like to refer the committee to the Hansard. The Honorable Senate met in 2017 on the, in 2020, sorry, on the 17th of July. And there was one member who expressed a great deal of concern about how all-encompassing this section seemed, and was a little bit afraid of the extent to which this could become an obstruction to the Parliament, as well as the example that he uses that it could become an obstruction to, as it says there, any person being employed or any concerned person who felt that it was their duty to inform the very Parliament of something might be obstructed by virtue of how this clause was written. It says every person having an official duty under the Act being employed or otherwise concerned in the administration of this Act, a concerned person shall regard and deal with as secret and confidential, and take a look at what is to remain secret and confidential. All information, statutory declarations, government contracts, prescribed licenses, and all other matters relating to any matter before the Commission. Now, I just want to share, because it was only last night I took a look at the old Act, and when I say old Act, a 45-year-old Act that literally mirrors and mimics the way 56.1 has been crafted. And what I found interesting, committee, is that the Parliamentary Integrity of Members Act, which was really the, I guess you could call it a fundamental anti-corruption law that did specifically look at parliamentarians. So these were our legislators recognizing that, yes, our Parliament, we need to look at the public officials, we can't forget about them. And I heard the discussion this morning, but I certainly think the public would agree that our leaders are leaders, and therefore their example matters. And I think that's reflected in this act in 1973 that spoke to how we handle statutory declarations, which is how we handle and how we assess what parliamentarians own, what they earn, and what they owe. What is interesting, however, is that though the same phrases and clauses are found, the interpretation for the last 45 years has not been the same as the way in which 56.1 has been interpreted. 56.1, in our view at JAM, has brought down this cloak, and it seems a little regressive in terms of what citizens can access specifically about public officials who have been investigated under the now Integrity Commissions Act. And let me give you two practical examples. Right now, we have to the left a report, even though it says March 2021, it was recently tabled by the Integrity Commission, and we have on the right their annual report. Now take a look at the difference here. One legislation, and we have one report submitted by the Commission, and citizens get a level of detail that I think is extraordinary and impressive, to the extent that we can even have the details of the conversations held in the examination and the cross-examination of public officials. It's to that extent. The ministers are certainly named if they are part of the issue, or any other public official for that matter. Deep, granular, couldn't ask for more. And then we get to an annual report. And what we find is an entirely different situation in terms of the kinds of information that's provided. However, these two reports are being done under the same legislation. Now, using JAMP as a case study, we have an MP tracker that most of our parliamentarians, because we've been bugging you recently for some information. As you know, each parliamentarian has a page, and this is just a generic design of what our page is. And on that page, we collect information we get from the parliament for basic attendance as an accountability issue. We've been looking at the Constituency Development Fund, and I know there are MPs who have been sending in. I want to just say thanks, and for those who haven't, we're still hoping to get them soon, those reports. But we also look at asset declaration. Now, this graphic here, let me blow it up just to show you what was possible in terms of what citizens could access as accountability information and anti-corruption information pertaining to parliamentarians under the old Act. This is what we had. Now, JAMP started tracking, when we started, we looked back 5 years like any audit does, and we looked at 2014, 15, 16, 17. The information on the left is the kind of information that would be detailed by the government coming out of the Parliamentary Integrity Commission, which was the entity responsible for assessing statutory declarations. Now, any citizen looking right now would be like, wow, Jeanette, seriously? We would be able to be told, and for the record, this snapshot is a snapshot of our actual parliamentarians and their record in terms of offences committed under the Act of the former Parliamentary Integrity of Members Act. But we would be able to tell whether or not they declared and who they were. We would be able to tell if they were late, because that is an offence under the law. We were told even if they were reported to their parliamentary leader, even though that is not required under the law. But the process honored the fact that citizens should know that if we've been trying and putting things in a cubbyhole and sending emails and calling you and you're not responding, we're going to report it to your parliamentary leader. And that was important enough for the reporter passed to let us know. If declaration wasn't cleared, we would know. If you were reported, you were going to be reported to the DPP, it would be in that report. It would not be in the report if you were fined, but JAMP had every intention of letting the public know if it had amounted to such. Now, this is what we have under the Integrity Commissions Act. You scroll up on our page, what you will see are all the different offences and information we think would still be relevant for the public. But in truth and in fact, what do we have? Absolutely nothing. And when we wrote to the Integrity Commission, the pieces of legislation or the sections that were quoted as a basis for denying the public this information was 53.3 and 56.1. And what do we get out of the, so let me just backtrack a little quickly and say, so this is the kind of information we would typically have gotten in the past. This is what we now have in the report that was just tabled yesterday. And I can see, and I think citizens would agree, that some of the issues here we're not given names anymore. So to be very honest with you, I think that is a serious lack of accountability. But we get the numbers of parliamentarians who have committed an offence. But as we look at them, we're seeing things that we say to ourselves, based on the conversation that took place in October, we can't think of any reason why we should no longer know if 30 days have passed and you've been given a notice and you're not responding, you've committed an offence under law. The people of Jamaica ought to know. If it gets as far as prosecution, that means the Integrity Commission has completed their investigation and have elevated it to that level. The people of Jamaica should know. And one of the reasons they should know, and we referred it in our submission, is that this speaks to an inequity in the law, whereby any citizen who is listening to this today found themselves in a similar situation where they were charged and up for prosecution, put to a public interest test. It is put into the public domain. And one of the questions we have is, why is it differing in practice in the administration of the Act as it relates to, for example, our parliamentarians? So we go down the list and we look at several things. Failure to provide information, you're being prosecuted, the public.
Bear in mind the Act doesn't only relate to parliamentarians.
Yes, what I'm doing here, Member Malawi Fort, is providing just 2 anecdotal examples. And I'm sorry, based on the discussion today, that I might have picked this one, but that is true. But time doesn't allow me to go into all the ways in which I think there's an inequity. But as I said before, I feel very strongly, however, that parliamentarians are our leaders, and therefore in setting the example, I think it was a reasonable example to utilize. And we get down to illicit enrichment, and there's one for investigation. And I think these are things that the public ought to know. Now, if we knew this for 45 years, how is it that we're in this new era of accountability and we're being denied this? It's difficult for me to understand. My second and quick case study speaks to the matter that Director Kevin Stevenson spoke to a while ago regarding the quarterly contracts database. Now, members, I have been in government and I've been interested in contracting for a long time. I only discovered that this amazing, impressive, best practice database existed about 3 years ago. When JAMP thought maybe this is one of the ways that we could add value to what government is doing, which is to start to collect this data, reached out to Mr. Christie, who was then, I think, still in Turks and Caicos, and said, what do you think of this idea? Mr. Christie said, Jeanette, this is actually on the website of the, well, at the time it was still the Office of the Contractor General. We went, and what we have here is an amazing database of 174,205 contracts, roughly all from the 1st of May 2006, 14 years. And great detail, the kind of things that citizens would want to know, and I have discovered that not all members of the media know. Now, this is important regarding the clause that we're discussing, because again, we believe that in some way, this legislation has actually pulled this information back into the dark and has stepped back in terms of transparency. Why is that? Because JAMP realized that, well, this is only 20 items of 179,000. Any citizen coming to this database, even I would put it to you, the Integrity Commission itself, is going to have a difficulty manipulating and navigating this. So we thought, in light of the trackers that we're providing, which are tools for government, citizens, and media, we would sell the idea to some of our partners, and the European Union and the IDB bought it. And so JAMP has been creating this procurement tool, taking this massive database, impressive database, and converting it into a data visualization tool that would make it easy for our stakeholders to utilize. Now, why is this so important? If you look for a moment to that section I've highlighted, this is basically a date graph, a timeline of these contracts. And you can immediately make an assessment as you see that curve going up. But if you look to the end, you will notice a sudden drop off. Why is that? That is because as of 2020, based on what the Integrity Commission has informed JAMP, when we continue to ask for why isn't this database being updated, we were advised that precisely because of section 56.1, and let me just run back to it very quickly for the sake of the public, which says that all information, I mean, it's incredible to me, that all persons employed or otherwise concerned in the administration of this act shall regard and deal with this as secret and confidential. What? All information, statutory declarations, government contracts, prescribed licenses, and all other matters. So what has happened is that the very people, the public of Jamaica, who's funding these contracts, are no longer in a position to know where this is going and to whom. So I put it to the members of the committee that I really don't think that I need to comment much on that. That's a most untenable situation, and we're really appealing and hoping that with your help, we will be able to reverse or recraft that clause and that provision, so that the public can have access to information that is rightly theirs. Quickly wanted to speak to the hindrance, the parliamentary duties that we also mentioned in the submission. This is a matter that I have never seen anything like this. And I am only going to comment to say that if this has never happened before, that the Contractor General or no other watchdog entity has been stopped or obstructed from receiving information from a commission that reports to them, I'm assuming, committee, that there is something in this legislation that the lawyers were able to find as an arguable point in order for the courts to have allowed an injunction, a temporary injunction that has lasted 5 years. Every attorney I've spoken to has said that is mind-boggling. But I am just sharing this on behalf of the public to say there is something in this act, and JAMP is of the view that this might go right back to 56.1. And the concern that was shared, which we can find in the Hansard, where that member indicated that you could find an obstruction in terms of the parliament being able to receive information. This is certainly one such. I'm really happy to say, though, that JAMP has received a lot of questions on social media about this matter. And in May, we did receive from the Registrar of the Supreme Court that a date has finally been set for the 2nd to the 3rd of November. And we're really counting on the fact that this will be able to happen. So our recommendation is that we would like to see some more consistency in the administration. We don't want to see a situation where reports during the year have a plethora of information and then we get to the annual reports. It is tabled, which is what the legislation says, until tabling. But when it is tabled, we're not getting the information that we as a people have been accustomed to getting. We feel that an interpretation of 56.1 that better supports the fight of corruption needs to be crafted. And certainly we would like to return to the openness and transparency that the public of Jamaica has had for 45 years, had under the 1973 Act. Very quickly, under 42.3, the publication of assets. There's not much that has to be said on this. I think it's just a quick comment on the fact that both leaders, the Prime Minister and the opposition leader, it is required under this section that there is a publication of a summary of their assets, their statutory declaration. But it has been a concern of the media. We've seen the editorials, we've seen letters to the editor, and certainly at JAMP and other CSOs that deal with advocacy, that there is this wide gap in terms of when we think, one leader reports in July and another leader reports 6-7 months later. We think that there should be a date by or a time by, because there's a lot of speculation in the public space when there's a delay in the publication of this asset. It's not an offense when it is not published, but we actually think it would be a protection for the leaders that there's a cutoff so that it doesn't continue to breed the questions that tend to arise when we don't get it and the public is concerned. And finally, conflict of interest. You'll recall last year we had the matters dealing with Nutrition Products Limited, where board members were receiving contracts. The Airports Authority matter, where a board member had been a part of a decision to invest money in a company where she was also a shareholder. And I believe also the matter concerning the chairman of HART getting contracts when he's on the chair. Now, I just want to say to the committee that no matter where you find corruption, you will find a conflict of interest. That's fundamentally the challenge that any public official has. Corruption at its basic definition is an abuse of the public power that has been given to you for personal and private gain. This legislation says it doesn't have to be your gain. It can be family, friends, associate. And it doesn't have to be money. It can be even a promise to do something for you, a favor and a blight. But ultimately, any public official having to make a decision and having an opportunity to benefit himself or somebody he cares about, or benefiting the people of Jamaica, that is the decision that he has to make. And the conflict of interest is when he chooses himself, and that leads to corruption. So because there's such a direct correlation between the two, we don't believe that a key piece of anti-corruption legislation should be silent on a matter such as this, and we haven't been able to find anything that speaks definitively to it. There are other legislations that really do a really good job. So for instance, the policy for the staff orders 429. If this had only existed in the Integrity Commissions Act, we would have been able to treat those matters, I think, very differently. If a public official uses information or any material that they gain from their official position for private gain, if they exploit the status and privilege of their own position for private gain, if they engage in transactions with relatives, and I particularly draw attention to if you own investment or shares in any company or undertaking, it's a potential for conflict of interest. The Procurement Act in its general provisions tell the public that public officials are expected to be free from interests or relationships that are actually or potentially detrimental to the best interests of the people of Jamaica, and shall not engage or participate in any transaction involving a company, its affiliates, divisions, or subsidiaries in which they have even minor interest. So it's very clear here, but the difficulty we have, for example, if the person is a member of the board or the chair, is that there's an argumentation that they're not staff, so it doesn't apply under the staff order. Then there's the fact that, for example, when you're procuring shares, my understanding is that the Procurement Act doesn't speak to shares as an asset. And so that's a major gap when we're dealing with that kind of investment in government. So I'm thinking, and I'm asking the committee to consider how you can close off that gap, both as it relates to investments in companies, as well as matters of members of board, which none of these two acts speak directly to. That would be one of JAM's recommendations. Now, I left this here because I didn't want to forget to say something to the committee as I close, and I didn't have a slide for it, but I have one concern, and I wasn't able, and I'm sure it's there, where exactly in the act that this matter is dealt with. But the whole idea that, and for the public who might not know, even 1 year after you leave the space as a parliamentarian, you are required to still report back to the Integrity Commission about your assets. And I want to propose, and I don't think it's going to be a favorable one, but I really think that it would be best if it wasn't limited to just a year. I would ideally like to see it extended to 5, but I don't think that would happen. So I'm going to recommend 3. And the reason for that is I have had a personal experience with this that I just want to quickly share with the committee. I was in government in charge of several housing developments on behalf of the Ministry of Housing. And I was coming in one day from a site visit in St. Anne. And a developer called and asked if I could stop by, and I did, a site in St. Catherine. He asked the staff to go along and he would take me in, and I said, no problem. On the way into Kingston, this developer, this was the first time, but it was not the last time, that I was being offered a gift. And the gift in this case was one of the service lots in the development that he was completing. So I was a little surprised because I thought these were the kind of things that would happen at the beginning of the project to kind of solicit, the most favorable terms in the contract to be negotiated. But this developer indicated to me that he was appreciative of the work that this public official had done. When I politely declined, and this is what is important, he said to me, oh, Miss Calder, you don't understand how it goes. What you must do is you take the lot and you put it in the name of your cousin. Make sure it says a cousin where you trust, because once you put it in them name, you can't get it back. So his assumption was that I didn't understand how the runnings go. And he went on to tell me that if I don't take it, it's an offense because they put on 5 lots. And he named out the agencies of government. Not the persons, but the agencies of government. And he couldn't leave out the Ministry of Housing. So the idea this developer was selling me is that I just have to wait it out for a year. He was already clear what the legislation said. I am saying that to the extent that some of the acts of corruption, whether it's a public official or a parliamentarian, often amounts to grand larceny, not petty theft, the idea of waiting it out for 1 year is not enough. I do believe that the Integrity Commission needs to be taking a look at who has left government, especially those in sensitive positions. Go ahead, member.
How did you treat with that developer, and what really should be done with him on the corruption front and investigation front?
Well, what I did with every single one that came along is that I reported them to my permanent secretary. I think where you're heading is that I probably should have reported him, but the reason I didn't, member for it, is that what did I have? I had nothing other than somebody offering and somebody was going to deny that. So there was no transaction. What I did with every single solitary case was just to report it to my permanent secretary. The best I could do under those circumstances, I thought. All
right. I want to thank you, Ms. Caller. Any other comments from members?
Yes. I wanted to end on a comment that Member Malo Hufort made also in October that I think is a really good note to end on. Her question at the end of that committee meeting was, what is the signal that we are sending to the public of Jamaica? And Member Malo Hufort went on to say that we have indicated a commitment to fight corruption. Agreed. We have to signal in the right way that we are not giving with one hand and then clawing back with another hand. And I just want to conclude, Member Chuck Chair, by saying that as it stands right now, and just some of what I've managed to share with the members, it could be interpreted that while this act has been strengthened and the institution itself, there are some serious gaps. And as you know, the weakest link really, it undoes the entire chain. So I just wanted to thank Member Malo Hufort for that, and to say that I don't think that the government or the parliament is clawing it back, but we have an opportunity to strengthen it where we find those loopholes. And I sincerely hope that the comments and the experience that JAMP has had with the legislation and the institution has been of some value to the committee today.
Yeah, thank you, Mrs. Collins. Let me be very clear. We want to strengthen the legislation if we feel that it can help to fight corruption, because we have no interest in promoting or escalating corruption. I mean, as a government, we know that we need to reduce corruption. One of the problems personally that I have is that, you know, the perception of corruption is as dangerous as corruption itself. And one of the reasons I said before, and I will say it again, Section 53, nothing is wrong with the commission put into Parliament at the earliest possible time that investigation has begun. And that can, once that is done, there's no problem, because at that point they are accountable to Parliament, that a report must come back to Parliament in an appropriate time to say what is the result of that investigation. When they put it out in a press release, what is the accountability? If nothing comes of the release, sorry, of the investigation, then a person's reputation might be tarnished and nothing is said afterwards if the investigation proved to be benign. I know of far too many examples where I know the commission has investigated. Take the Ministry of Justice. There's no contract that the commission has not investigated over the last 3 years. No contract. And I know this because they write the ministry, and the permanent secretary tells me as soon as a contract is announced, they want all the information about the contract. Suppose some joker write the commission to say, you know, this contract was given out for whatever reason, and the commission now say we are investigating. Remember, you know, they are investigating all contracts, but they now pronounce that we are investigating. That immediately not only casts doubt about the contract, but the contractor might be put into question, and the ministry would be put into question too. And at the end of the day, to the best of my knowledge, all the contracts that have been done in the Ministry of Justice have all been, not all, but many of them have been investigated by the Integrity Commission. But to the best of my knowledge, they have all been benign. I have seen far too many situations, you see, and I will give you one or two which I know, where because, and to be exact, because it is felt that ministers may have interfered, requests have been put to the Integrity Commission publicly to investigate. To the best of my knowledge, Integrity Commission investigated them. But because they were benign, nothing has come of it. But if the Integrity Commission had said, we are investigating these two matters because ministers were involved, can you imagine the reputational damage? And in these two cases I'm thinking of, nothing happened. Yes, Mr. Stevenson. Director Stevenson, you wanted to say something.
Thank you, Chairman. Just to clarify for the record, it is probably not accurate to say that all the contracts have been investigated.
Many of them.
There are two processes that we have here. One is a monitoring process, which monitors the process, the procurement process along the way. And if there is a need to investigate, then that is when we would launch an investigation. But generally, we monitor most of the government contracts awarded across the public sector of a value above $500,000. So it's not that we investigate them all, because we wouldn't have the capacity to investigate 6,000 contracts, for example, but we monitor them. So it's fair to say that we monitor. And when it is necessary, we will investigate.
All I know is that I've been informed that on a regular basis, your various contracts that the ministry say have been engaged in. No, I just want to say, Ms. Calder, that, you know, let it not be said that we are in any way trying to restrict disclosure. For instance, you mentioned the Administrator General. The Administrator General, you know, those investigations at the end they present a report, and their report anything.
Member Chuck, if I may respond to that, thank you. It gives me an opportunity to re-emphasize the point I was trying to make, however, in the presentation. There is no reason at all. The agency that created this problem, as a matter of fact, it boiled down to an individual. So I don't mean, and I really hope I'm not saying this in a way that will come across offensive, but it's a human resource problem that the government had. It was not something across the length and breadth of government. That entity doesn't exist, that agency doesn't exist. And I have every bit of confidence because the parliament has created an institution where there is no concentration of power that existed in the old. It was pretty much an individual that could make that call. We have the commissioners, we have the directors who have their own certain amount or level of autonomy. And we've had a country who for 3 years has been ventilating the extent to which this is a concern. I do have the confidence that the Integrity Commission would be able to handle investigations and any kind of announcement or comments in the manner that MOCA does, in the manner that the Auditor General does. And I feel that to indicate that they can't, it actually raises even more questions, because if this institution, with all the power that we have given them, including that given to the Director of Corruption Prosecution, cannot be entrusted with something that we've all fundamentally agreed is inappropriate, then we have a bigger problem than just the mere matter of, inappropriate comments and press releases. That took place over maybe 10 years ago. And I think there's a danger of a single story in maintaining that this is something that is going to continue. And while we are concerned about reputations, there has to be balance. As you said, that thing about the perception is reality is true. And the way in which the Integrity Commission has been muzzled for the last 3 years, it has bred certain amount of concern and speculation in the public realm, and just the lack of assurance that our concerns are being dealt with. So when I weigh the balances, I would say, let us trust this institution that you have strengthened, that you have flattened the power, you have given them a kind of hierarchy that I think will benefit us in a way in which this will not return.
Member Bunting?
Go ahead.
Member Bunting want to, and we have to wrap up in a few minutes. Member Bunting?
Thank you, Mr. Chairman. I just want to ask Ms. Calder. She mentioned two things, and I forgive me if I can't remember the references, but essentially that the Integrity Commission, the Parliamentary Integrity of Members Act 1973, had a identical provision to what the Integrity Commission Act now has. And it was not interpreted in the extremely conservative way that it is being now. Similarly, that the first couple of years that the Integrity Commission was in existence, it continued to publish the contracts, which were not investigations. It was just an administrative publication of the award. And then at one point, they decided to adopt that very strict conservative interpretation of it. Is it not, just really an attempt to pressure the parliament to change the law? That is my impression. And let me be clear, I have, myself gone back and forth in weighing the considerations. And I am of the view now that they should be allowed to state when an investigation commences, and then nothing else until the report of the investigation is published. But at the same time, the Integrity Commission seems to be taking a very activist approach to pressuring Parliament. And I just mentioned, I'm speaking for myself. I'm not speaking for anybody else on this committee or any party or Parliament as a whole. If they, at some point though, having made a recommendation, is it appropriate to be pressuring Parliament to act by withholding administrative information, which was routinely published under the same act? It seems to me that there's a bit of activism being pursued by the Integrity Commission now to pressure Parliament to do what they want, unnecessarily so, withholding information that is not necessary to withhold.
What I would say, Member Bunting, is what I would be comfortable commenting on, because I can't comment on the motivations of the Commission. But I'm very comfortable saying that the provision that the Commission might be drawing on to allow that could be strengthened, and that's why we're here today. It is so all-encompassing. It has lent itself, as I have said and you have reminded the listeners, to an interpretation that did not exist before, exists now, but the Commission has every right to interpret it that way because of the way in which it has been crafted. And what Jamp is saying is, let us tighten it up. So if in fact the commission is so motivated that it would be clear. And if in fact the temporary injunction that has become almost a much more than a temporary injunction granted to Mr. Hales, I could easily see how he has sought protection under a clause that says everything should be withheld. And that is in effect what 56.1 has said. 56.1 has led to an interpretation of the commission that has now had us what, 2 years of withholding procurement information. So we need to strengthen that.
Respect, a report of an investigation or an investigation is entirely different from administrative reporting of the award of contracts. Those are two entirely different things.
Entirely different, but more concerning that the parliament cannot get
what I'm saying the point I was making is to elevate routine administrative reporting, to start withholding that as a means of pressuring the parliament to change the law in the way that they want. Is that appropriate?
If that is what they were doing, there's no way that could be appropriate, Member Bunting, but I can't comment on why they're doing it. I can only comment on let's hurry to fix it so that there's no such loophole if in fact that is what is happening.
Yeah. All right, thanks, Member Bunting. Member Fort, and then we have to wrap up. Member Fort.
Chairman, since we're wrapping up, let me thank all the presenters through you, culminating now with Ms. Calder for the presentation. Because I know that I continue to keep an open mind in listening to the presentations, and that the commitment of the government, the anti-corruption and promotion of integrity is not mere lip service, it's not easy work, given the culture of Jamaica, a culture that is, it's not only the hustling and the runnings and the violence, it's just a high level of lawlessness. And so our work is really cut out for us as not just a parliament, but as a nation. I am yet to be persuaded that the Integrity Commission is muzzled. I am not persuaded that it is, given the functions that are set out at Section 6. I don't know how many reports have been made post submission of reports to the Parliament on the matters, meaning after the timeline set, how it has been done. If it has been done, I'll just have to look back to remind or inform myself. I believe, so the primary reason that has been given for the need is because people think that the Integrity Commission is comatose, and that the restriction on reporting prior to a certain point in time is giving the impression that they're doing nothing. I am not persuaded by that argument at all. I do not believe it is the same thing as interfering with transparency, as it were. I think that there is so much work to be done in this area for which the Integrity Commission has remit, and which is critical in the fight against corruption and in helping us to achieve the goals, that this focus, for me, I am, given my own professional background and monitoring these issues over decades, any matter that is going to lead to a criminal prosecution, those matters must be treated with a certain level of care, because we're always competing between probative value and prejudicial effect of disclosure, premature disclosure, handling of information that will have to be presented as evidence. There is a certain level of integrity that has to be protected. I believe that the remit and the work of the Integrity Commission is so wide and so critical and so important that there is much to be done, and nobody could reasonably believe, given its budget, its structure, and the work being done, that it is comatose. But I keep an open mind.
Thanks again. We have to close now because the staff, they have another meeting at 2 o'clock and they need some time to at least have lunch. So I want to thank all the members who have participated today. We apologize to Jamaicans for Justice and Jamaica Lands. We did not reach you, and we have no doubt we will be in touch with you when we have the next meeting. and the Integrity Commission will be afforded the opportunity to complete its presentation. And I've also got the 2 documents you sent on Monday, Mr. Christie. So on behalf of the members and everyone, we would like to thank everyone for a fairly interesting meeting. And we hope that there will be, further discussions along these lines when we meet again. So thanks to everyone, and thanks to the secretary, who I know is recording, and I know have another meeting at 2 o'clock. So thanks everyone, and we can now a motion for adjournment, please.
Thank you, Chair.
Moved, Chairman.
Second.
All right, wonderful.
Good afternoon, everyone.
Afternoon, everyone.
Good afternoon, Chair. Thank you very much.
Thanks, everyone. Good. Okay.
Thank you.